Yes.
In the meantime, the director is present himself, and in the meantime, 15/12/2025, so far this admitted dues is concerned, it is amounting to rupees 4,64,804. It has already been disbursed.
Already.
My learned friend may ensure it, my lord.
I have not.
Anyway,
My lord, that I have given the bill, my lord. I am given the details, my lord. I am also serving a copy upon my learned friend.
Right.
And so far this
In terms of order dated 17/10/2025 and 8/12/2025, OP number 2, we personally present before the court,
yes,
submits, so and so submits that a sum of rupees 4 lakh
4,64,804.
804 is paid to the petitioner after doing some calculation
on 16/12,
on 16/12/2025. First one.
through bank account, my lord.
Through bank account. Bank. First one. Thus, there is substantial compliance of the subject order.
And so far this admissibility of the headmaster pay scale, it is in the process. It will take little bit time.
Anyway, we will give time now because it
Yes,
has
ma'am.
complied with the order.
Yes, ma'am.
The swift action taken by OP number 2, Mr. So and so, who is personally present before the court to assist in the proceedings, is appreciated. First, registry to share a copy of this order with OP number 2. Okay.
Vacation.
Next.
After vacation.
After first week of second week of item 2.
May I please lordship? Let them give.
Your client has not told it because you will ask him for fee.
Right, tomorrow after lunch it will be done.
That's one. Yes.
May I please lordship? Annexure 1, the impugned order. My application order 7, Rule 11, Clause D. 7/11
For dismissal of the suit.
I have filed this application for dismissal of suit against the son-in-law who was filed for suit for partition.
It's a suit for partition.
Partition.
OS number? CS number or OS number? What is
CS number.
CS number. All right. CS number.
231 of 2018.
231
of 2018.
2018.
Pending before the civil judge, senior division, Jagatsinghpur.
Senior division,
Jagatsinghpur.
Jagatsinghpur.
Annexure 2.
Your application is rejected. Your defendant number?
I'm the defendant number 1.
What was the ground you had taken?
1D of the
Read CPC.
CPC.
711 1B.
1D.
1D.
11D.
711D.
D.
That is a
law.
Question of law.
But by law.
Order by law.
The law is,
Law parts.
the law is order 1 rule 9.
Order?
1 rule 9.
Order 1
Rule 9. Misgender and non-gender parties.
No, that is not considered as law.
And
It's a
it is not in the schedule. Son-in-law is not the co-personal.
okay. In a partition suit in CS number 231 of 2018, petitioner being the first defendant had moved an application under order 7 rule 11A for dismissal of the suit as being barred by law. First, the said application having been rejected by the impugned order, this petition is presented against the same. First, next paragraph. Learned counsel for the petitioner vehemently argues that the non-joinder of necessary party or misjoinder of parties would be would fall within the idea of barred by limitation. Inwards, barred by law. The expression employed in the said provision, and therefore the application ought to have been favored. First, this is difficult to agree with. First, next paragraph. a series of decisions of various high courts in the country have held that whether a particular person is a necessary party or not, whether there is misjoinder of parties or not, is a mixed question of law. And therefore, ordinarily, that cannot be tried in an application filed under Order 7, Rule 11D of CPC 1908. First, in view of the above,
May I please?
no case is made out for it.
One.
Next paragraph.
Well,
Even otherwise,
well,
it is open to the petitioner to put the order in question, the impugned order, as a ground for challenging the judgment and decree if entered against the interest of the petitioner as provided under Order 43, Rule 1, capital A of amended CPC. First, in view of the above, petitioner.
may I please, Lordship, one line? May I begin up to? The son-in-law has no cause of action to file the suit for petitioner to have a co-person.
The question is not that.
My letter, this is the only.
These are the matters. Ordinarily,
Against
the application for dismissal of suit should be treated very strictly.
and should be remain, but this person should be.
No, that will not.
Only.
No, that will not fall into.
The person only.
Next. Item 3. Urgency. What urgency?
The DO replaced the headmaster without any notice, sent a notice to replace in his post.
Replaced means removed from the.
For the post of headmaster. He is appointed by the managing committee since 2024 to till date. But 10/12/2015.
Take it. Yeah.
Sorry, my lord.
All. Item 3. Yes. UJC.
It is a matter of 96, in fact. And Mr. Sangneria is no more. Possibly on his death.
Other advocates are there.
Others are there.
It is submitted at the bar that learned counsel Shri S.K. Sangareria has expired. First, issue court notice to the
Party concerned.
appellant. Na? What do you call it? Petitioner or appellant? What do you call it?
This is your petitioner.
Petition.
Earlier nomenclature was UGIS. Earlier nomenclature was UGIS.
Okay. Item 4.
May I submit my law? My lord, this is prayer for appointment under rehabilitation assistance scheme. This is the debt chart.
It is rejected,
My lord, it has been rejected twice.
but then it requires consideration of.
No, my lord.
Here, my lord.
My lord.
The technical difficulties is.
No, my lord.
I'm submitting for yours.
Yes.
Date of death is 2015, my lord.
Date of
Death.
death.
26, 2015.
Correct.
Then applied for this application on 28/9/2015, my lord. And yes, as the petitioner was on field, then subsequently filed an application when the son attended the majority. That is on 11/3/2019. Am I clear? No?
Yes.
So applied when majority on 2019, applied on 4/3/2020. My lord.
That is within
1 year.
1 year.
Yes, ma'am. In the meantime, my lord, the new amendment came into force on 7/2/2020.
7/2.
In the month of February 2020.
17 to 20.
17 February 2000. For that ground, whether it will come the period when it new rule came into force.
No, apex court in one decision. There are conflicting decisions of the apex court. One VV, the application should be treated in terms of the rules as they existed.
That is an Assis Avesti.
My lord, may I submit? This has been decided by my lord's decision and thereafter confirmed by the Honorable Supreme Court just recently. Only 1 hour.
That Jita Lua, my lord. The pending cases which is kept pending prior to the new rule came into force.
The application with the father who has died prior to 1916 or 2016 rule, that will be covered under the 1990 rule. And the discharge certificate which has been available prior to the 2016 will be taken into consideration. Or let the case may be discharged just 1 hour. Just 1 hour after. I have
1 hour?
1 hour after, my lord.
Just to bring that judgment.
Yes, I have brought that. That is in the file, my lord. Even 10 minutes after, I shall bring that.
Pass forward.
Item 5.
Use this in there.
Petition is now the work is a principal matter. The Hon'Ble College in page 49, the so-called notice under challenge issued by the recovery officer EPFO Miller. There are 27 employees coming under purview of EPFO Miller. They are governed under Granted Order 2017. Where there is a demand of 97 lakhs 16,017 towards penalty and EPFO contribution Miller. My case is Miller due to COVID-19. The institution could not be deposited the EPF amount before the authority Miller. That's why there is
When you should have deposited it?
I have 27/12/2024. I filed a representation praying for 72 installments.
Amount was payable when?
My lord,
When amount was payable by you?
amount of payable Miller is 2014 to 2025 Miller.
No, you can't say like that.
24.
The amount which was payable before COVID, that you should have paid.
And there's
For
a,
other payments, I can understand.
yes.
For other, where is the case for you? You deposit 75% of the amount. For
And-
other amount, I'll give you stay.
That's a
Otherwise, I'll
90,
dismiss the
and
case.
it is too difficult on a part. Then the
Therefore, we
96,
dismiss it.
and there is 97 lakhs Miller. The institution having no income sources except the fees Miller, no other income sources Miller.
That makes no sense.
We've deposit
That is applicable only on that, which is that your Jolly George Joseph's Bank.
No,
of
we've
Kochi.
partly paying the institution, partly paying.
Issue emergent notice. Learned, any panel concern on
Dear my lord, that EPF, they are panel of lawyers and central government panel of lawyers.
you appear for whom?
No, my lord, I cannot appear.
Okay, issue emergent notice. First, an application is moved in IA number 15573 of 2025, supported by an affidavit seeking stay of recovery pursuant to impugned order. First, learned counsel for the petitioner pleads COVID-19 difficulty as a ground for first. This cannot be fully accepted in as much as greater portion of the period is before the onset of COVID-19 pandemic. First, however, regard being helpful, all the facts and circumstances of the case and the difficulty pleaded before the court, financial difficulty pleaded before the courts, application is partly allowed, and the impugned order is stayed, subject to petitioner depositing 60% of the amount in demand before the which authority?
EPF.
It will Commissioner Bhubaneswar.
Before OP number 2.
OP number 2.
OP number 2.
No,
No, Miller.
OP number 3.
OP number 3.
OP number 3. OP number 3. Within as 20% within 1 week, 20% in the next 2 weeks, and the last 20% in the 1 week next following. Filling which interim order stands vacated on its own. Okay.
Item 6.
Yeah. Petitioners got a plot, F category plot is under CDA Development Authority. Due to communication gap between the petitioners and the CDA Development Authority, petitioners would not get a plot, my lord. My grievance is pending before the authority, Annexure 6 series, my lord.
In that, what you have sought for?
Short part, kindly give a F category plot.
Who are the OPs?
OP's CDA, Auto Development Authority.
Take notice. Show emergent notice. Remember within 3 weeks. Next.
Item 7.
Or we'll direct them to consider representation.
Yes, yes.
Take note. Short grievance of the petitioner is as to non-consideration of his representation dated 9/9/2025, a copy whereof avails at Annexure 6. Where he has sought for allotment of a plot at Abinka Binansi, what is that?
My lord,
Allotment of plot.
I don't have category plot.
Plot. In the F category. In any CDA project area. First, counsel for the petitioner submits that if an order is made to pass order on the subject representation, he is applying to this service. First, next one. Notice to OP is dispensed since petitioner's prayer is innocuous, inasmuch as he seeks an order to pass an order on the representation. First, next one. In the above circumstances, petition is disposed of, directing the OP to consider the subject representation within a period of 6 weeks. First, all contentions are kept open. It is open to solicit any information, etc., etc. Next paragraph. Registry will send a copy of this order to exhibit post to OP.
Item 7.
Yes, Lordship, item 7,
Yes.
I am on virtual modularship.
Yes.
Item 7 challenge the order, the apartment allotted in favor of the petitioner before 27 years, my lord.
But
After
you it is only show cause notice.
Spoken notice I have submitted. I am in panic, my lord. May cancel
No,
the.
I say that they should not cancel without taking your cause.
Yes, Lordship.
I will protect you.
Yes. Yes, yes.
Petitioner is laying a challenge to the show cause notice dated. Where is that? Dated.
And dated 12/8/9. Dated Annex 3, my lord, 26/8/25.
26/8/2025, copy whereof lies at Annexure 3. First one. The notice reads as under. Next paragraph. Learned counsel for the petitioner submits that although his client has submitted the reply, he has apprehension that without considering the said reply, adverse order may be passed on the basis of the subject notice. First, this apprehension petitioner need not have, inasmuch as once cause is shown in terms of the show cause notice, no adverse order would be passed by any sensible authority without considering the same. First, in the above circumstances, petition is disposed of.
Item 8.
Obliged.
But pursuant to your lordship's order, my representation for counting my seniority from the year of allotment has been rejected under Annexure 9.
Take notice. The DG requested to accept notice for the copies. Yes.
Item 9.
Item 9, please. Lord, petitioner's prayer is for May I please, madam? Lord, petitioner's prayer is for evaluation of his thesis paper, which he has submitted way back in the year 2012, my lord.
2012.
Yes, my lord.
Now what should happen?
My lord, they have not yet evaluated the thesis paper, my lord.
How long the paper should be kept by the university?
My lord, already thereafter, after 3 years of submission of thesis paper, they have communicated under Annexure 3 that that is at page number 33, 3, my lord. Annexure 3
That
series.
was 33/2015.
2015, my lord.
But then what happened?
Then thereafter, my lord, in compliance to that order, I have submitted the published paper, my lord. On page 34, my lord, I have also complied the direction. Thereafter also, my lord, they have not violated the procedure.
You have given the representation to whom? Commissioner from Secretary, Department of Higher Education.
Yes, my lord.
Who
What
should give the degree to you?
my lord, the university.
Then you make the representation to the university.
Yes, my lord. But that has been also been forwarded by the I have also made the representation to the UGC, my lord. They have all,
UGC?
yes, my lord, university.
What UGC will do?
Because, my lord, they are stating the reason, verbally they are stating the reason that as per the guideline of the UGC is required to interfere in this matter, my lord.
Take notice.
My lord, I will submit representation.
None. I will not take it. If a case for dismissal of this notice. Yes, next.
My lord, that is, my lord, only, my lord, I have a glance to the page number.
Issue emergent notice. Learned AG is requested to accept notice for one emergent notice to the best. Okay.
Item 10. Item 10.
Item 10 possibly in person because no name is reflecting in the cause list.
You take notice.
This is not a board of secondary education. Notice is to be
You are
issued to the board.
Issue emergent notice. Shri, so volunteers to accept notice for the office. First, call this matter on 15, 16 of January, 14%, date has to be given. Any case, you can give some date. Yes. Date. Yes.
Sir,
What?
Item 4.
This is the recent document.
Upon by the Supreme Court.
জিতালুয়া নাকি সেই কথা রেডি করে দিলেন না তান্ত্র মনে মা ওর লিখে আছে ঠিক আছে
My lord, page 32.
Yes, 30.
32.
Malad on 4/4/2025 Government of Odisha has
Issued a notification.
issued a notification, and on the basis of that, Jitalua also disposed by Hon'Ble Apex Court in the month of possibly May. That your lordship also considered in the earlier occasion in many cases.
Brother, we will have it immediately after vacation.
Yes.
I want to examine. There are two judgments. We'll have it immediately after vacation. Right?
My lord, there are also that, my lord.
Malad, whether notice will be there or will take instruction?
No, no.
Are you not served notice? AGA, when he is requested to accept notice for the office. Matter lies in a very narrow compass. First, function for the petitioner's office, it is covered by the judgment of the apex court. First, therefore, post this matter in the second week of January 2026.
My lord, in the meantime, the matter is being considered by the DO.
The pendency of the petition that will not come in the way of considering petitioner's case in accordance with law. Okay.
Item 11.
Covered by Hemant Kumar Choprae. Similar matter has been passed by the coordinate bench. Similar matter has been passed by the coordinate bench. I am submitting the corresponding copy of the order.
The subject matter of this petition is substantially similar to the one in WPC number 17067 of 2023 and batch of matters disposed of by a coordinate bench of this court. Wide order dated. You have to look into that order. Dated 12/1/2024. Learned counsel for the petitioner submits that in view of the above judgment, judgment. The relief granted to the litigant therein needs to be extended to her client. on the principle of merit. There is force in this submission. Next paragraph. This only for consideration. In the above circumstances, the petition is disposed of in terms of order in the cognate petition. With that is noted this.
My lord,
Item 12.
my lord, item number 13 and 14 is the same matter.
13, 14 also.
Yes, ma'am. My lord.
Ah. Then, yeah.
Item 12.
Yeah.
The regular teacher, if a termination without any proceeding, that was set aside by this court on the unanswered by coordinate bench.
Release of annual increment.
Annual include in similar matter, coordinate will already issue notice.
Issue notice. The DG is requested to also notice for the office,
All of which.
all along with WP number signed. So,
Right.
Item 13 and 14 have been disposed of. Item 15.
Anything urgent?
15 is urgent.
Somebody else.
Oh,
No, no, he asked to urgent, but as it was in
case for admission, right?
Also,
Regulation of service of petitioner as per guidance lines of
Item 15. Refer short urgent.
Representation is pending, madam.
Who has to consider?
That is UP3.
UP3.
Yes.
UP3 is
UP3 is Director Higher Secondary Education Odisha.
You consider representation then?
Yes.
Short grievance of the petitioner is as to non-consideration of his representation dated the 21/3/2025 at an exact 6, wherein he has sought for regularization of his service. Counsel for the petitioner submits that if the direction is issued for consideration of the subject representation in a time of which, justice should be meted out to his client. First, with this proposal, counsel for the agent Lanka appearing for the OPs is agreeable. OP number 1 to 3 is agreeable. Notice to OP number 4 is dispensed with since it is not a necessary part. It is not a necessary. Next line. In the above circumstances, petition is disposed of, directing OP number 3 to take a decision on the subject representation within a period of 6 to 8 weeks in accordance with law, and to communicate the same to the petitioner as well. First, all contentions of the parties are kept open. It is open to solicit. Next.
Item 16.
Can you see Hemant Chopra, HK Chopra case? Neat appeal is pending.
16.
Yes.
Subject to outcome.
Outcome, sir.
Come on. Yes.
Item 17.
Please, your lordship, on behalf of Mr. Devendranath Mishra, my lord, that the petitioner is claiming for arrear salary and also your lordship.
Annexure 3 is
To be considered.
Yes.
Similar orders we have made, na?
My
Item 18.
item 22. Beg pardon, my lord.
During the order of rejection, annexure 8, page 36 regarding revised scale of code. This is a cover to deploy case. This was directed to consider. Now he is rejected.
Take notice. Length also.
Yes, sir.
Yes.
Item 19.
My lord, the petitioner challenged the inaction of the authorities who are not taking steps to issue the death certificate, even though her husband has been died in the year 2012, my lord.
Why, brother? Why you
It cannot be. It cannot be.
See,
Her husband has not been died. He is missing. Yes.
how long?
So that is the police report, my lord.
How long he has been missing?
2012.
Then
So
section 710
evidence.
Evidence Act says.
Yes, ma'am.
He has to go to the civil court.
No declaration is this.
Yes. Yes, madam.
My lord, earlier the petitioner has approached the sovereign court.
That I'm
Just a minute, let me finish, Mr. Lekau. Let me finish.
Yeah.
My lord,
Where is the proof of death?
death, my lord, I have annexed, my lord, annexure
Annexure 1, my lord, your lordship will find that he jumped into the river and was missing. And his dead body was recovered, and it was photograph was taken by a person that was identified by his own sister, my lord. And thereafter,
It's a serious matter.
Serious
Suppose what he says is right. The,
well,
section, there is one section, 108.
108.
Wait, your preparation is insufficient. My preparation is more because I have seen several such cases. No, there are two sections in the evidence. One section says, where a person was shown to be existing in the last 30 years, it shall be presumed that he still exists. There is such a decision by the Privy Council, number one, which you may not know. Perhaps you do not know. Another is section 108, which says, if the whereabouts of a person are not heard for a period of 7 years by those who ordinarily would have heard of, then there is a presumption of civil death. It is a loose presumption. Merely because you have lodged a complaint and somebody identified. Where is the postmortem report?
Nothing. Postmortem dead body could not be recovered.
If dead body could not be recovered, then where is the proof that he jumped into that water?
My lord, if there was lord,
That makes no sense.
my lord, his cycle and sandals which he was wearing and the dresses which he was wearing on that day, that was found in the river. Yes.
On the basis of 108. That's how courts have held it. Sarkar on evidence has said that 108 presumption benefit can be taken by filing a suit. We cannot presume that way. Suppose if he comes tomorrow and on the basis of this order, you gain employment.
My lord, you will also kindly have a glance at the earlier order passed by this Hon'Ble Court. I have quoted that order in my writ application.
What it said?
Hon'Ble Court directed the petitioner to file a petition before the adjudicating magistrate. The adjudicating magistrate was directed to take a decision. In that case, in pursuant to directions of this Hon'Ble Court, I filed a miscase before the adjudicating magistrate. That was not aspected, that was not numbered. I sent that through the registered courts. That is still pending, my lord.
That will direct him to consider that that order we can do.
Yes, yes, but your lordship.
Petitioner seeks a direction to the OPs for issuance of death certificate of her husband, who is alleged to have died by drowning. Full stop. Petitioner was before this court earlier in WP number.
My lord. Two occasions. My lord.
In WP numbers.
Yes, sir. WP number, my lord. 16172 of 2015.
And another.
Another, that was the withdrawn, my lord.
Withdrawn.
That was the withdrawn to file this. 16172 of 2015.
15. Disposed of on?
Disposed of on 4/8 to 2023, my lord.
2023. Whereby liberty was reserved to the petitioner to approach the judicial magistrate first class under section 13 of the Registration of Births and Deaths Act 1969. 69. First. Next paragraph. Once and for the petitioner submits that once a person's whereabouts are not heard for a period of 7 years by those who ordinarily would have heard them of, there is a presumption of death, and therefore a direction should be issued to the authority to grant registration of the death and issue the death extract. First, learned EJ Mr. Lanka vehemently opposes the petition, contending that only of the presumption arising under section 108 of the Evidence Act 1872, as it then was, no such direction being issued. First off, he highlights the abuse potential of the decision of the kind if pressed into service as a precedent. First, I am in agreement with the submission made by Mr. Lenko that the petitioner should ordinarily approach, persons of the kind should ordinarily approach the civil court for working out their grievances. First, be that as it may. Next paragraph. Since it is the submission of the counsel for the petitioners that his client has already made an application under section 13 of the 1969 Act, comma,
In pursuant to directives of this Hon'Ble.
in terms of direction of this court in the earlier round of litigation, comma, justice of the case would be met by directing the with GMFC.
No, my lord. Executive matter. Executive matter. Tahsildar Raghunath.
Directing the
OP number 3, my lord.
OP number 3 to take a decision on the subject application if it is still pending within a period of 8 weeks.
I have submitted through registered court.
We do not know if it is pending, they will do that. We do not know. You have not produced anything here.
I have produced my lord. And it's for my lord. I have not
Where is the register post?
registered court I have given. I have given my lord.
You have sent it.
Page 30, and the track report, page 31.
But then they will pass this order. Okay. All contentions are kept over. We say make it 8 weeks. 8 weeks. Petitioner to appear before the Tahsildar. On which date you will appear before the Tahsildar?
Your lordship may please have a date after 1st week January. 1st week January.
That's date some date. 2nd week of January. Fine. So along with a copy of this order. 9th and take instructions at the hands of the Tahsildar.
Item
Next.
20. Item 20. 19.
My lord, on behalf of Diptinandan Mahapatra, kindly taken up after 2 p.m.
Take note. You take notice in the execution order.
No,
Huh?
your lordship may kindly see Annex 8.
Then in his absence we cannot take.
Yes,
After vacation.
he has made an attempt to mislead your lordship.
Indeed.
Yes.
Item 21.
21.
My lord, 21.
My lord. My lord. Item 20, my lord, kindly pass over it.
Pass over.
Pass over.
Item 21, my lord, item 21. I am for item 21, my lords. I am for item 21.
My lord,
Annexer 2, page number 10. I have filed the
Your is 20.
20, my lord, 20. Pass over.
After vacation. Yes.
My lord.
to SIM was inactive. That is at page number 12, Annexer 13. Union imposed but not answered to my answer. My SIM is inactive, which I suffered a lot in the train.
My lord, I may be permitted to submit, my lord. Lordship may kindly.
You appear for OP.
I am for the Union of India, my lord.
The notice is issued to you.
Notice, he has sent an
Copy is given to you.
email he was sent. Lordship may kindly come to the prayer part, my lord. The question he has put is not against the Ministry of Railway, my lord. It comes under the purview of Ministry of Electronics and Information Technology.
But you sent that requisition to the concerned, that the section.
My lord, he has only made Ministry of Railway party.
Take out that act, RTI Act. RTI Act says there is a judgment of apex court also, where an application is made to an incompetent authority. He should forward it to the competent authority. You can't say I'm incompetent authority. You will be working you will work as a postman. In that case, you will send that mail to the competent authority. There is such a decision.
I may comment it, my lord. The grievance which he has raised before Ministry of Railway, they have adjudicated and imposed fine. The other part which he is answering is questioning, that is not under the purview of Railway, my lord. The writ petition he has filed, the prayer portion is to
Then file objections. File short objection. Issue notice. Learned CGC.
Senior panel counsel.
Senior panel counsel Sri so and so appears for all OPs.
Well, one OP, the Minister of
OP.
Railway.
Calling the last week of January 2026.
Copy may kindly, sir.
What copy is not given to you?
He has sent me email.
Petitioner to furnish a copy of the petition with along with all the document immediately to the learned panel, senior panel counsel. Okay. Next.
Item 22 has been disposed of. Item 23.
Well, my claim for regularization and pension has been rejected under Annexure 4.
Rejected?
Yes, madam.
Take notice. Yes. Same acceptance notice for OPs.
Item 24.
Under the petition challenge Annexure 11, where the representation of the claim for antedated service has been rejected. Annexure 11.
Notice.
To antedate her services.
AG appears for OPs. Yes.
Item 25.
What is this matter? Password. Will issue notice. Issue notice. The ASC requested of some notice for OPs. Emergent notice to OPs.
Item 26.
May I please proceed?
Yeah.
Petitioner is retired headmaster, my lord. After completion of 30 years regular service, he has got to second and third RSCV with a grade pay 4,200 and 4,600.
Well, what we have done in other matters?
Other matters, my lord, in the meantime, notification of letter.
What is that?
And the petition approached before the Lord and Tribunal. Tribunal allow the original application. Then government approached before the Hon'Ble High Court. High Court upheld the Hon'Ble Tribunal's order. And the government also approached before the Hon'Ble Apex Court. Apex Court also upheld. In view of the Hon'Ble Apex Court judgment.
Where is your representation? Is it rejected? No.
No.
Representation is further slashing the impugned order.
Impugned order Annexure 8, man.
It is rejected now.
Not rejected.
Yes, therefore, deduct your short path.
They deducted. Deducted my salary.
That's all. Now,
in this regard, no representation, my lord.
Take notice. Let us examine.
May also directly in view of the Saraswati voice case, my lord, that he may be filed a press report.
No, that only I am against just giving direction to consider the representation. Nothing is going to happen by that. No, that is, we will not consider also. They will be driven to the court for contempt and other things. Therefore, we will decide the matters. Wherever possible, we will decide. Wherever not possible, we will direct you to consider.
That Saraswati voice case recently affirmed by the Hon'Ble Apex Court.
Correct.
And the impugned order is in the year 2024.
24, that is before the issuance of the decision of the Apex Court. Now, if he gives a fresh representation, we will consider in the light of Apex Court decision.
Yes, not simply similar matters.
We have done that way.
Yes, yes.
Petition prayer reads as Learned counsel for the petitioner submits in view of decision of Apex Court dated 9/9/2025 in SLPC number 8465 of 2023 between State of Odisha versus Saraswati Bhoi, etc. The petitioner should be permitted to file a representation with the direction to consider the same if filed. First time. Learned AGA is agreeable with this proposal. First time. In view of the above, petition is disposed of, reserving liberty to the petitioner to make an appropriate representation supported by evidentiary material within a period of 2 weeks. And if one is filed, one is made, who should consider? OP number OP number, my lord. 3, my lord. OP number 3 shall consider the same. In the light of apex court decision in Saraswati Boy Supra. Within 8 weeks. First, all contentions are kept open. It is open to solicit information, documents, so now no words.
Till not to further reduction.
Till a decision is taken on the representation to be made, no coercive action shall be taken against the petitioner under the influence of court.
Item 27.
What is the guest teacher? You will also similar matter. Similar matter. Guest teacher claiming weightage. The similar matter has already been tagged.
Notice we should.
No, only tagging.
Notice. Issue notice. The requested from some notice for the all of the piece. Call this matter along with WP 33141 of 2025. Yes.
Item 28.
Item 28, petitioner has challenged the reservation principles that has been followed for appointment of junior teachers, Lordship. Already, Lordship, similar identical matter is pending before Lordship.
Pending?
Yes, Lordship.
Show emergent notice. KGA saying accepts for both the battery numbers 1 and 2. Emergent notice to the rest. Call along with WP numbers, right? So, yes.
Item 29.
Any representation is it better? It is not there. That's why it is rejected. You take notice. Similar matters are there, na? Which Mr. Swain had a file issue notice. Committee AC accepts notice for OPs. Yes, call this matter along with connected matters. Similar matters. Okay.
Item 30.
My lords, the petitioner is an employee of Council of Higher Secondary Education. During period of his service, he was sent on deputation to CBSE, Central Board of Secondary Education, CBSE, from Council of Higher Secondary Education, Orissa to CBSE. He served there and repatriated. But as per the term of the employment, the CBSE is liable to pay pension contribution and leave salary during the period when he was there. CBSE, in fact, has paid substantial part of it. Some remain due, for which CHSE has recommended that this is the amounts due after you have paid substantial amount. The residual amount is this, please pay this. CBSE is sitting over that.
Minister of Education.
CBSE has got the parent
council here.
We'll issue emergent notice and call it the second week of January.
As your lordship, please.
Issue emergent notice. CGC 3 so and so appears for OP number 1. For CBSE, Rob appears.
Mr. Tarananda Patnaik is appearing.
Tarananda Patnaik, the panel to accept notice for the rest of the OPs. Matter lies in a narrow compass. Call it the second week of January. Yeah.
Second week of January.
Yeah. Great.
Item 31.
State Education Tribunal take notice and it needs examination. This emergent notice by Raji State accept notice for OP numbers 2, 3, 4, 2 and 3. Emergent notice to 1 and 4. Okay.
Item 32.
May I please your lordship, the petition was a block grant employee and retired from service on 30/6/2020 seeking pension matter. In the similar case, your lordship has disposed of the matter in WPC number WPC 34015 of 2020.
Copy of the order.
I have not copied it.
WPC
34015 of 2025.
When it is disposed of?
2/12. 12/12/2025, my lord.
12/12.
12/12.
This is the operative portion of that order.
In light of Hemant Chotrae,
You should bring at least copy of the judgment, nothing, no preparation. If lawyers come this way, as if they are coming to the marriage dowry, what the judge should do? Do that.
My lords, kindly see the prayer. Your lordship may
The benefit of pension and other pensionary benefits due admissible in terms of Project Rule 381 rules and favor of the petitioner within short stipulated period. Where is this is not, that is not, this is different. Hemant Kumar Chotra is not that case.
my lord, the extension of the pensionary benefit has not been extended to the present petitioner. For that reason, was filed.
Take notice, brother. Just look into it. You should always come with full preparation with your form sheet. Nobody brings the form sheet. There is no such culture at all in your law. Yes.
Item 33.
Preparation.
Similar method.
Issue heard for the petitioner. The subject matter of this petition is substantially similar to the one in WP number 72, which is being heard by this court. First of all, let's see the next matter. Let's see that. Same order. Call along with the WP number. January. Yeah, January 19th. 19th of January. Don't put the date. Call along with. Oh.
Item 34.
Yes.
May I please, Your Lordships? Lord, the representation of the petitioner as directed by this honorable court, my lords, by Annexure 6 was rejected, my lords. By Annexure 7.
Take notice. Issue emergency notice. The PGM is to the right requesting to accept notice. What?
Sole opposite, only one opposite party, my lords, is the college.
College of in that government college it is.
I'll take note.
Requesting to accept notice for also. Yes.
Item 35.
Your my lord, the petitioner challenging Annexure 7, wherein in the case of the petitioner for early
Keep your mic properly.
Your my lord, petitioner challenging Annexure 7, wherein in the case of the petitioner for early withdrawal of the charge of in-charge headmaster of Baipur Primary School for petitioner and hand over the same to the senior most teacher has been rejected. Now your lordship see Annexure 7, the ground on which they have rejected. Last but 3 paragraph, my lord.
My lord, there is a stay order in another case, my
In
lord.
another matter.
Yes, that is why,
This matter, the WP 2710 of 25.
my lord, that is 758 of 2024, filed by some other persons. That is why final decision could not be taken, awaiting final
So you
result.
accept notice, will call this matter along with that matter.
Here, my lord, his representation has been rejected. His case has been rejected under Annexure 7, my lord.
Issue emergency notice.
7 kind.
Annexure 7.
Notice for
Kind 7.
OP number 124, emergent notice to 5. Right. Call this matter along with the, which is that connected WP number?
My lord, so it is 35. Sorry.
Different matter. Anyway, you take notice because there is rejection, it requires
Yes,
examining.
my lord.
Okay.
I am holding a.
Next.
Item 36.
This is the other case I was pointing out.
This
Annexure 6, Annexure 6, page 26.
Issue emergent notice. Mr. Behra is requested to accept notice for OP numbers 1 and 2, emergent notice to 3. Emergent notice to 3. Call this matter along with WP number
758 of 2024.
Okay.
Item 37.
Second round of litigation, my lord, claim of the petitioner to get the revised UG scale of pay has been rejected on Annexure 11.
Similar matters
Issue notice.
Issue emergent notice. Behra is requested to accept notice for OP 1 and 2, emergent notice to OP3. Or
Item 38.
yes.
The petition is a level 4 graduate teacher, retired from service on 31/12/2024. But deprived to get the on-the leave salary of 300 days. They have only sanctioned 188 days, remaining 112 days salary on the leave salary has not been paid, madam.
You are entitled to 300 days?
Yes.
Under which rule?
As per the leave rule, madam, and similar benefit has been given to another person, that is Annexer
Take notice.
6. No, Annexer 8 is pending before the OP number 1, madam.
88, if 80 is considered, that is sufficient.
Annexer 7, BOQ I have repented, thereafter it was referred to the government, madam, under Annexer 8, that is pending page 23, madam.
Petition prayer reads as that. First, counsel for the petitioner draws attention of the court to his client's representation dated 2/5/2025 in copy whereof avails at an exhibit wherein she has requested additional security to government for sanctioning of remaining unutilized leave period by way of encashment. First, he further submits that leave encashment is permissible to the extent of 300 days, whereas only for 312 days, 112 days.
Annexer 5, page 20, 188 days they have sanctioned, page 20.
Whereas the authorities have sanctioned the claim only for 188 days. And therefore, there should be a direction to take a call on the subject of certification. With this proposal, learned AGA Mr. Behura is agreeable, subject to the caveat that all contention should be kept.
OP number 1, madam. Problem.
Item 39.
My prayer for antedatation of date of reinstatement under Annexer 5 representation is pending with OP3.
Petition prayer reads as that. Counsel for the petitioner draws attention of the court to the representation of claim dated 25/4/2025 at Annexer 5, wherein the request is made for granting reversal to his grievance, as has been made out in the representation dated 16/10/2024. Addressed to DU.
Opposite pattern number 3.
OP number 3. When it counsel for the petitioner, if a direction is issued to take a call on the subject representation in the light of the issue of the appendix in the civil appeal number 4632 of 2024. When it was decided?
The Annexer 2.
On 2/2, as per the rule, that's 2, the client would be satisfied. First, with this proposal, counsel for the AGA Mr. Behura appeal in front of OPC is agreeable, subject to the caveat that all contention should be kept open. First, next, payments. Who should take call?
OP3.
OP3. Yes.
Item 40.
पास सिमिलर होगा देखिए क्यों जो रिप्रेजेंटेशन दोनों कॉपी पूर्ण मिल के बोर्ड
ओपी नंबर
2 no
can you make out this one? This put
Item 41.
May pleasure. Annexer 2 page 9 is pending for the OP3. That may be considered lost since 1 year.
What is
that is the complaint before the work council.
Forgery and manipulation.
Mine.
By whom?
The concerned.
To take notice. Issue emergent notice. AG is requested to Behura accepts notice for one emergent notice to the rest.
Item 42.
May I please? And the petitioner was working as a demonstrator and retired from service in since 2020, my lord. Government has extended the benefit of UGC scale of pay to the demonstrator, my lord, since 1986, my lord. But the petitioner has paid the UGC scale of pay from 1986 to 31st 1295.
Annexure
No, sir, no.
considered.
Yes, my lord.
Consider annexure. You will appear for UGC. You appear for OP?
It is 43. No, he is 43. It is 42.
This is 42.
Who should take a call on the representation?
One, my lord. Opposite party number 1.
OP 1.
Yes. He is not secretary, my lord. He is retired employee. So secretary.
Petition clear the examiner questions. Same question. Consent for the petitioner's attention of the court to representation dated 20 June 2025 at Annexure 7, wherein the OP number, commissioner is which OP?
One, my lord.
OP number 1 is requested. Go to Annexure 7. Requested to make payment of to do the recalculation of arrears paid in pursuant to the letter dated 3/10/2024 and make the payment of differential amount. First, London Council submits that if a direction is issued to consider the said representation in a time-bound way, justice will be meted out to the third line. First, with this proposal, Council G is agreeable subject to the condition that all contention should be kept open and the reasonable period be granted for taking the decision. First, this is fair. Next, 8 weeks. Over to solicitor. Yes, next.
Item 43.
My lord, it is limited prayer for correction of name.
Correction of name in?
Name from MD Salim Mandal to MD German Mandal, the same person. And representation is there under Annexure 8 and affidavit under Annexure 6. And though it has been published in each paper, affidavit 37 page and Aadhaar.
Take notice. Take notice.
Notice.
Because municipal
notice
for one.
For one only I can receive.
Emergent notice to the rest.
Project number 4.
Correct, but let notice go in the come. We'll have this post immediately after service upload this. Requisites within 3 days. Okay, working days.
Item 44.
Second round litigation, Annexure 16 is under challenge. Similar matter, lordship issue notice.
Notice, G requested to notice for 4.
Notice
3 and 4.
Notice
emergent notice to 190. And follow along with WP number.
Item number 43, yesterday 43.
Next matter.
Item 45.
Right, item number 45.
45.
So item number 45, may I please, Lordship? Here is a case. The petitioner was initially appointed in the BSA Millard. Thereafter, one inquiry was conducted by the opposite party number 3 through the Tahsildar, concerned Tahsildar. On a report given by the Tahsildar that the petitioner is not a original domicile of the state of Odisha, basing upon that report, my provisional candidature has been rejected by the opposite party number 3 Millard.
Take emergent notice.
Yes, Millard.
Yes, you are appearing for the opposite party number 1 to 5.
Mr. Paddy, let me DSP appear for all OPs. 1 to 5.
No, OP number 1 to 5, man. The state is the number 6 and 7.
It was the notice for 6 and 7.
So G will appear for 6 and 7.
Yes, Millard. One small prayer, the inquiry report, Lordship may direct the state to produce the inquiry report. I approached the Tahsildar on several times.
Your prayer.
Yes, Millard.
Let
after hearing it,
then we.
Yes, Millard.
Item 46.
Item 46 is covered by the ratio decided in Saraswati Bhui's case.
We have copy of the judgment.
Yesterday, matter was there similar to item 44. Your lordship has corrected the.
Can I
Here-
pray, my lord? Annexure 6 may kindly be seen. There, while passing the order, it is quoted. Learned Advocate General present in the court today has submitted that this batch of appeals is covered by both the policies referred to above, and the government decided to extend the RSP scheme relaxing criteria. As such, so and so they have accepted the directions as issued by the High Court and shall complied with within a period of 3 months from today.
Yeah.
This order was passed on 1/11. 6/11.
No, 6/11 is your letter.
No, it is
It was passed on which day?
1/9. 9/9.
Yes.
Now, my lord, 11 to 3 months have passed. So, lordship,
Then I thought made that order.
I thought that it was passed on 1/11.
Letter. That's what I immediately noticed.
In item 44, your lordship has corrected yesterday's item 44.
I corrected that for this.
My lord. The lordship directed to file a fresh representation.
One thing we should not get. Yes.
All are similar.
Item 47.
Petitioner is a junior lecturer. A proceeding was initiated against her under Annexure 3 at page 70. And the inquiring officer was appointed. Inquiry was conducted and the report was submitted under Annexure 9. That is in favor of the petitioner.
Inquiry report is in your favor.
In my favor.
Then what happened?
But without considering it, now the discipline authority has directed for de novo inquiry.
Fresh inquiry is ordered.
Fresh inquiry is ordered without specifying the what irregularity in the main inquiry.
Where is that order?
That is order under Annexure 10, page 44. May I read it? 5th paragraph. And
Yes,
where
Mr. G, where is the reason?
there is no reason.
Once inquiry is held,
Yes.
it is open to you to reject the inquiry report and come to your own conclusion after hearing him.
Yes.
You can't say hold de novo inquiry. Generally, unless
Yes.
there are such grounds, which is that famous judgment of Apex Court, 2006 Supreme Court. You can't hold a de novo inquiry that Justice Krishna Dixit on de novo inquiry. Karnataka High Court. You can't hold a de novo inquiry that way. Nobody will be safe tomorrow. You can't expect a particular kind of report. If there are reasons, you can say that you don't accept the report and we will arrive at our own conclusion.
Assigning a reason, we can.
Yes. Issue emergent notice. G requested also notice for the witness. Any stay is case what for?
I have filed a
Application in I number 2304 of 2025 supported by an affidavit by seeking a reprieve against the proceedings. First of all, the counsel for the petitioner submit that the first inquiry having been ended, having been concluded in favor of his claim, a fresh inquiry cannot be ordered for no reason. First of all, there is some justification for this submission. First of all, in the whole circumstances, application having been favored, the pending inquiry has put in suspended animation during the pendency until further on.
inquiry pursuant to Annexure 10.
One exact 10. Unexact.
Item 48.
May I please your lordship? My lord, the petitioner is a Sanskrit teacher.
Doing. Yes.
May I please your
To
lordship?
take out that judgment. When I say something you should do that job because that becomes helpful to me in the rest of the matter. Yes.
My lord, the proceeding, disciplinary proceeding was initiated against the petitioner annexed 2, page 10, your lordship may see, as per rule 16, my lord. That is a procedure for imposition of a minor penalty. But your lordship may see annexed.
Major penalty? No.
They have imposed a major penalty. Page 33, your lordship may see, the first line says also, Annex 10, page 33.
Mr. G, what the apex court says is, where you intend to hold proceedings for major penalty, it is open to you to levy the minor penalty.
Yes.
But having said that you will hold proceedings for minor penalty, reverse is not true.
No.
Issue the merchant notice. Learned AG is requested to accept notice for the OPs. Within that Supreme Court decision which says TOO inquiry cannot be held without abundant justification. An application in IA number 22476 of 2025 is
22145.
22145.
145.
Filed along with an affidavit seeking reprieve during the pendency of the petition. First of counsel for the petitioner submits, and this court for the time being agrees with it that once a notice is issued for holding the disciplinary proceeding for imposition of a minor penalty, major penalty cannot be levied. First, next paragraph. In the above circumstances, application having been favored, there shall be stay of impugned order at Annex 10
dated
24/4/2025 until further orders. Next.
Item 49. Wrong fixation of RSCP. Similar matter already issue notice, my lord.
Issue emergent notice. G accepts notice for OPs all along with WP.
34999/25. What is that number, sir? Item 50.
May I please?
Yeah.
No, since 1997, my lord, after allotment of a provisional plot to the petitioner society, they have established a hospital. And thereafter, my lord, they deposited, the lordship will find
You show cause notice, brother. You show cause. In the event they reject that application, you will have a cause of action.
I have been representing before them for many occasions.
That's true. They have issued show cause notice now.
Annexure impugned demand, my lord.
Demand.
Annexure 18.
Of show cause notice.
Now they say that you deposit. I have deposited already 25 lakhs. Another 25 lakhs they are imposing, my lord, towards interest. Although the infrastructure fees and charges have already been deposited. Your lordship will find that I have submitted that receipt.
You deposit 50% of the amount, for remaining amount I will give stay.
My lord, may I pray?
Emergent notice. Learned AG requested to accept notice for 1 and 2. Emergent notice to 3 and 4. First, counsel for the petitioner presses application in IA number so and so supported by an affidavit saying that his client has already made an entire deposit long ago and therefore demand of the kind cannot be raised now. But he also submits that he has made several representations earlier and despite that demand has been wrongly raised. First, matter requires deeper consideration. Next one. In the above circumstances, application having been partly allowed, the demand notice dated 31/5/2025 hereby stayed at Annex 18 is hereby stayed, subject to petitioner depositing 50% of the demand amount within in 2 equalized installments of 2 weeks each. Benefit.
My lord, may make it to 3 installments.
2 installments. Next.
Item 51.
51, my lord, claiming for regularization, my lord have already issued notice 51, 52. 2 orders I have given, corrected.
You are corrected.
My lord.
Similar order.
Similar order, my lord, I issued notice and protected.
You.
I have given
notice for same.
Item 53.
53 मैंने covered by Himanshu Travel. I'm surprised.
Good. 50 is good now. Yes.
Item 54.
May I please, your lordship.
The petitioner is a retired teacher. He retired from service on 31/3/2023. Lord, he has been favored with high plaques towards gratuity instead of 16.5 months of pay as per the rules. My lord, he has made a representation to the district education officer. Your lordship may direct the OP number 3 to consider this same.
Petition prayer will said and counsel for the petitioner draws attention to the court to the representation dated 29/11/2025 made by the client at the annex report, wherein the request is made for sanctioning gratuity amount at the rate of 16.5 months of pay instead of consolidated amount of ₹5 lakhs. In terms of extant pay rules of 2017. Yes. First, learned counsel submits that if a direction is issued to consider the subject representation in accordance with rules, justice would be meted out to his claim. First, with this proposal, counsel represented ASC Mr. Seni appearing for the OPC is agreeable. Next verse. 8 weeks. Who should consider?
OP number 3.
Item 55.
Your lordship, kindly see page 70, my lord, for a moment. 70, my lord. I have earlier approached this honorable court. Your lordship directed. Lordship, kindly page 71, the last paragraph. In the above circumstance, the petition is disposed of reserving the liberty to the petitioner to file his objection to the drone survey report within a period of 2 weeks, producing all vouching material in support of the objection, and that till a decision taken by the jurisdictional opposite party on the said objection, no corrective action shall be taken against the petitioner solely on the basis of drone survey report. And pursuant to lordship order, lordship kindly page C73, I have filed my objection on 3/9/2025, my lord. And thereafter on 6/10/2025, I have also filed a letter that I am ready to pay the cost of the drone survey. And the competent authority, the mining officer, who is the competent officer, lordship kindly page 94, wrote a letter to the ORSAC that to give your view with regard to the drone survey, and the petitioner is ready to pay the cost, my lord. Thereafter, the page 95, ORSAC rejected my prayer, my lord, on the plea that there is no discrepancy in the previous report. Relying the order dated 3/1, the impugned order has been passed, my lord. Lordship page kindly see page 100, Annex 15, my lord.
Wait, brother. Let's second of issue emergent notice. Any application you have sought for?
My lord.
Accept notice for the OPs. Application in IN number moved.
2245 CB.
Seeking stay of the stay of all further proceeding pursuant to impugned order dated 18/11/2025, Annex 15. First, learned counsel for the petitioner draws attention of the court to the earlier round of litigation, which permitted him to file his objections, and accordingly he did. First, despite that, and also despite he being ready and willing to pay the cost of drone survey, a wrong decision has been taken, which requires deeper examination. First, next point, the above circumstances, application having in favor, the impugned order dated 18/11/2025, Annex 15, passed by OC number 4 is stayed until further orders.
May I submit one thing?
Yes.
Lordship, can you glad to page 96, my lord. Annex 13, my lord. That is the order sheet of the mining officer, my lord. I am indulging, my lord, middle para, my lord. In reply to the above letter, the chief executive ORSAC, my lord, has submitted his view by letter dated such as wherein he has informed that the drone survey of Arua BSQ 18.88 acres was re-evaluated and found that there is no discrepancy in the previous submitted report. The report was prepared.
Previous report, which we found defective. He says it's in appeal or our decision.
Lord, the petitioner was permitted. He had permitted for 6 meters.
My lord, petitioner has never.
My lord, he has permitted. His excavation limit is 6 meters. He has drawn, my lord, 36 meters. My lord, thereafter, my lord, He was evaluated and found that there is no discrepancy in the previous submitted report. The report was prepared on the lowest surface height of 45 meters as per modified mining plan, and excavator has been drawn up to depth of 36 meters as per the drone survey conducted on 28
February
2025, which implies that excavation has gone beyond 6 meters from the lowest contour line, lowest line of the lease area. Therefore, my lord, he has gone beyond.
We'll stay for a period of 4 weeks. Then you file objections and then we will hear them. For a period of 5 weeks. Okay. It is open to the office to file their objections in the meanwhile.
Inquiry judgment. Judgment. Chairman CBDT versus Chandrika. 2024 division bench.
Correct. Myself and CM Joshi.
Yes.
That judgment we should take. Yes. Thank you. Yes.
Item 56.
56, well, this is covered by Ritanjali Giri case one.
Next.
Item 57.
This is covered by Saraswati Bhai case, my lord. But he has not made representation, my lord. Yesterday's item number 44. Published.
Item 58.
May I please, Your Lordship? Well, earlier there was an impugned order passed by the director for withdrawal of granting it. After my retirement of 4 years, Your Lordship passed that order in page 67. On 16/10/2025, Your Lordship stayed that order. Now, my regional director has passed that order. Upon being aware of the aforesaid
matter is still pending.
Yes, madam. Your Lordship issued notice, state the impugned order.
Issue urgent notice. Learned ASC Mr. Sen is referring to also notice for OP numbers 1, 2, 3, 5 and 1, 2, 3, 5.
Yes, ma'am.
Correct. One number J5 is to 4 and
5.
Why you have made 5 double duplication? 5 and 6 it should be na?
It should be 6.
I'm sorry, but there's a mistake.
You make it just correct.
Well,
6 and
that is 6.
6. An application is moved in iron number so and so supported by affidavit. It will reprieve against the impugned order dated 4/11/2025 at Annexure 1. First, counsel for the class draws attention of interim order granted by this court in connected WP number
28875 of 2025. Page 67.
First, a case is made out for grant of reprieve in view of the said interim order. First, next, in the above circumstances, application having been favored, impugned order is stayed until further orders. Call this matter along with WP number. Can I come back within a couple of minutes?
My lord, limited grievance, my lord. Petitioner is presently working as associate professor. My lord, is agreed by the inaction of the opposite party to appoint him as the head of Department of Physics in BSc, my lord. A detailed representation has been filed by the petitioner, citing the 41 of the statute, BSSUT Act, my lord, stating that by the
Who takes the decision on that?
my lord, the Vice Chancellor.
You take notice then.
OP2, my lord. My lord, I have
Issue emergent notice, ASC for 1, emergent notice 2, 2, 3, 2 rest.
My lord, may I request? My lord, I have the representation I have filed, my lord. Now the post is vacant. So if my lord may direct for consideration, that may suffice.
Annexure 3 is the representation. It is 22.
Issue notice. London ASC accepts notice for one. First, notice to rest of the OPs is dispensed with since prayer of the petitioner is for an order to pass order on his representation dated 21. 2025, a copy whereof avails at an exhibit 3 wherein he has sought for consideration of his client's case. For his consideration of his case for placement in the office of head of the Department of Physics. In terms of which rules?
My lord, in terms of clause 41(2) of statute of VSHUT.
In terms of clause 41
clause 2.
41 clause 2
of statute of VSHUT.
Of the university statutes. First term, the counsel for the petitioner submits that if a direction is issued to OP number 2, to take a call on the subject representation, justice will be dictated to the first term. There is force in this submission. Next paragraph. In the above circumstances, petition is disposed of, directing OP number 2 to take a call on the subject representation in accordance with law within a period of 8 weeks. First, all contentions of the parties are kept open. First, next paragraph. Since this order is issued, ex parte, it is open to the OP numbers 2 to 5 to seek its rescinding or recall as the case may be. Rooms do exist therefore. First, otherwise, the order remains intact.
Much grateful, man.
Item 60 to send copy by speed post.
Item 60.
235. Item 60. Yes.
The present writ application is filed for refixation or upgradation of the pay scale under RSC scheme. Covered. Item 61. 61 both count. Same matter.
61 both are covered.
Same, similar matter.
Similar. Representation dated?
Yes, but not
same order. Yes.
Item 62.
In the light of
the judgment rendered by the original coexistence as well as the reputation as well as judgment of the launching section. I have indicated it in the prayer.
Even thereafter also, government has issued notification to verify the status details.
Item 64.
Connected practices also. 63
yes. Yes.
Recovered.
Well, not may I please. Well, not the benefit was extended in 2019 and now by Annexure 6 and 7 they are going to recover, my lord, after cancellation. Your lordship has passed the identical order, Annexure 8, page 35. Same.
Notice.
I will corrected your lordship.
You are corrected? Same one.
Only your lordship in the third, fourth paragraph.
It is prefix passy.
No, your lordship simply issued without notice. Only your lordship may I pray, my lord, recovery is halted pursuant to Annexure 6 and 7, your lordship. Pursuant to Annexure 6 and 7.
Stay of recovery pursuant to
Annexure 6 and 7. Obviously.
Call along the WP number. Yeah.
Item 65.
May I please, your lordship?
Yeah.
The petitioner has an innocuous prayer, your lordship. The petitioner, his grievance is that pursuant to completion of his course as B Pharma, he is not being registered as a pharmacist. Your lordship, kindly say Annexure 5. Under Annexure 5, a similar candidate before this honorable court and is honorable to directed them to consider this representation, on the basis of which, under Annexure 6, the opposite parties, they accepted his candidature and he was enrolled as a pharmacist. So I pray that, my lordship, that this case also petition be permitted to make a representation before the OP number 2
for consideration of his case, keeping in view Aisha 5 and 6.
Similar matter it is.
Yes, sir. So Aisha 5, page 21.
The subject matter of this petition is substantially similar to the one in WP number 18893 of 2021, disposed of a coordinate bench of this court by order dated 19/8/2021, a copy whereof awaits at Annexure 5. First one. At the paragraph 5 of the order, it is observed as a first one. Next one. The net counsel for the petitioner submits that his right will be satisfied if the similar relief is extended to him in terms of the cognate decision. First one, there is force in this submission. Next one, in the above circumstances, the petition is disposed of, granting the same relief as has been accorded by the coordinate bench in the cognate petition, that is of.
I'm grateful.
Item 66.
Yes.
Sorry, now 66, that matter minor, the principal was minors involved in misbehaving the latest objective lecturers minors in the college. And that is what minors the government inquired and gave a transfer order to some other different place for colleges minors. Thereafter, the petitioner come before the Hon'Ble High Court. Hon'Ble High Court considered the petition and ultimately it was dismissed and rejected. Modification and if application filed, it was rejected. Then minors, the order was not complied with, I have come before the minors. On minors directed the pendency of the writ petition, shall not bar the government to transfer the petition that case for to some other place. Pendency of that minors, the government also issued a notice minors, issued the letter. That is at minors on page 10, next to 2. Thereafter, what happened? The sub-collector relieved him. While matter stood thus, the petitioner again come up before the Hon'Ble Court, before Milers, and Milers passed the interim order in Annexure 5. Yes, 16.
Shift him to other place.
Other places, in nearby places, Milers. Now what happened? Basing upon that, the most unfortunate, by that time he was relieved. Basing upon that, the sub-collector passed an order minors in Annexure 6, restoring the reliever.
Preposterous, my lords. Lordship's order is immediately posted. Lordship's order is immediately posted.
Case is contempt. The contempt of other cases are coming. Without
Obviously, my lords, yes.
They have argued the other cases.
I'll tell you, it still works.
Now you shift him to some other place, na?
That is one more aspect.
My transfer order, they have challenged. Whether they have any opportunity to challenge my transfer order. Or they have tried to this other to relieve him and allow him to work. Now that person, he is continuing since last 37 years in that place.
No,
I'm working for 9 years. 37 years he is continuing. And during the stage of GIA, he has lived for 9 years.
Anyway, now you suggest what should be done.
I am filing the reply to their intervention petition. You come after vacation for hearing of all cases. It is coming for contempt. You will argue for the contempt. Whether that the contender has violated any order or not.
That is what I mean.
No, you are not arguing in the contempt matter.
Well, that is that contempt which I am saying, my lords.
You said which order they have the contender has violated.
Exactly, that is what I brought it before, my lords.
In the third connected matter, may I submit? There are a series of matters filed by the principal who has been added as OP number 6 in the writ application. Time and again, keeping in view my lord's order, in first order, my lords has said on 23/9/2025 that the punitive action and the order of transfer has not been stayed or halted by this Hon'Ble Court. Subsequently, while considering the another application, my lords has passed on 30/10/2025, wherein my lords has clarified the same, not, this is from Cuttack to Ganjam. So nearby place, taking into advantage of the same, that order has been recalled by the authority. So if at all, sub-collector, my lord, if at all the person, as per the order of transfer, it will be transferred, then everything, because there is a complaint committee report against the person concerned also. And entire system of education is being.
All right, where there is a vacancy, you transfer him to that place so that all matters will be over. Yes.
But that.
I will call it at 2 o'clock. You are certain. Where is the vacancy? We'll post him to that place.
Yes, ma'am.
Yes.
In the main case, in the main
Why are you
Because
disturbing
by
his
the-
position?
I am in charge. I have been put in charge. I have been put in charge by the order. After I assumed charge, my lord, again I have been relieved.
Now let us.
correct. We are not taking any chance.
And I'm taking, let it be at 2 o'clock. By that I will take the instruction.
Come at 2.
In the first case,
Wait for me.
I have also given the option that number of institutions there are vacancy.
Yes.
You also ask your client where he wants.
Nearby could immediately.
You ask your client also. You are left.
By that it will be convenient to.
That we will give them. Everything will be.
It will dispose of all the cases.
They have tell and mind responsibility.
That's all right. Now you just ascertain. If
The nearby vacancies.
in nearby vacancies,
Yes, ma'am.
where I can accommodate your client.
Number of cases, the identical bits are displayed in the coordinate bench. They had filed the writ appeal. Writ appeal
Item
pending.
67.
They again they have filed this case.
Item 67.
During pendency of the writ petition, some development have taken place. The principle of lease, the government, the land, GA department land was allotted in favor of me along with other. So in the meantime, the interstate dispute, it is referred to the law department for final disposal. So my subject representation of the year 2017. So I pray, I will file a fresh petition before the law department along with others. So that the law department, they are now taking decision. So I shall be one of the participants to that proceeding. So I'll file a fresh petition before the law department and law
So
department.
in terms with liberty, it should be disposed of.
Dispose of with a copy number 1 to file a fresh representation.
Learned counsel for the petitioner having argued the matter for some time. So that is 67, right?
67.
This is 67.
If liberty is given to the petitioner to file a fresh representation, which OP number would consider in a time-bound way.
OP number 1, ma'am.
OP number 1 will consider in a time-bound way. Justice would be meted out to him. First, with this proposal, counsel for learned EGA is also agreeable. First, in the above circumstances, petition is disposed of, giving liberty to the petitioner to make an appropriate representation. And if one is made within 2 weeks, the same shall be considered by OP number 1. Giving opportunity of law, after giving an opportunity of hearing through all the stakeholders.
All the stakeholders.
In the matter. First, all contentions are kept.
Item 68.
Wait, please. 16.
Item 68.
State's review is not maintainable.
Yes, sir. The review is not maintainable. I have got the order, your lordship.
24C order.
Yes, your lordship. But with the corrected copy of the order I have got. Also serving copy on my senior.
The subject matter of this petition is substantially corrected everything.
Yes, your lordship.
Same.
Much obliged.
Item 69.
And for the opposite party, I have not received the copy of the amendment petition.
I am sharing the copy of the IA I have filed for amendment of the writ petition.
Amendment?
Yes, sir.
You want to amend the writ petition, let him amend, you file the objection after the amended petition.
That protection, but I have received the copy just now. Your lordship, as any order protecting the right to object, if any.
After 2 weeks. You want to file objection to this?
I have not gone through it. I have said that.
They will call it after the occasion. After vacation.
There is an interim order.
Interim order to continue. Calling the first interim order to continue.
Item 70.
My lord, I'm seeking a minor correction in the order dated 18/4/2022, passed in IN number 4857 of 2022. My lord, the writ petition was filed.
22 order you want rectification?
My lord, the interim order dated 18/4/2022, passed in IN number 4857 of 2022. My lord, the writ petition was filed for protection of the right of egress and ingress of the petitioner through the government land to the public road. My lord, while issuing notice in this case, the Honorable Court granted it as an interim measure. In the event the petitioner is not finding any alternate access to its land through plot number 681, particularly black mark portion at page 12 of the brief, there shall be no obstruction of egress of the petitioner till next listing of the matter. My lord,
that was in this was issued in 2022.
My lord,
This is in 22.
my lord, in the place of my lord,
Now you argue the main matter.
my lord, my lord, allow the correction in the
No correction. Order main matter itself you argue. Correction of which order? After more than 3.5 years. All these years, where were you?
My lord, the matter is not listed. My lord,
why it should be listed? You should have pressed for application.
Let me fix a date for hearing. Will
call in the third week of January 2026 for final disposal.
My lord, till then,
No. Next.
Item 71.
May please, Your Honor. This matter relates to regulation of a service matter. With 10/3/2023 notice has been issued, but till that no counter has been filed. And accordingly, we have filed a IFR fixing an earlier date of hearing. Lord.
First week of February 2020. It is. Yes.
Item 72.
Interim order to continue. Lord. Interim order.
Item 72.
In this interpretive application, we have a small prayer, my lord. We want this honorable to direct the SP Balesur to render police assistance to Office Department of 4 for carrying out this honorable court order, my lord.
What was the order?
The order was
Is there a government name?
20 July 23 order.
My lord.
That was a time-bound order for within period of 2 months.
2 months.
You argue the main matter, ready? Argue the main matter.
And this petition was already disposed of. Disposed of.
Was disposed of?
My lord.
What kind of order is it? Even interim order will not be like that.
ये तो कॉपी दे ये कौन भी दीजिए ये तो कौन भी दे दीजिए
Complaints.
I do not understand the order. Read the order.
Madam. Madam, considering the submission of London Council appealing for petition on the petition involving request for working out the direction wide Annex 2. This court in disposal of the writ petition observed in the event order number 6 dated 15/4/2023 passed by member Child Welfare Committee Balesur, if not obstructed by any further proceeding from higher forum. If that order is not been challenged in the higher forum,
should be worked
out at least within period of 2 months from the date of communication of this order by the petition.
Means what?
We will communicate this order to the Child Welfare Committee.
In relation to child, what has happened?
To get husband and wife. Main matter is husband and wife. The wife was having illegal relationship with others, and wife left husband place, and she has taken the child with her. So we file a petition to get the custody of the child as for welfare of child. The member Child Welfare Committee have inquired that it is better if child will be handed over to the father. That order was not
Well, under which section of which act the committee passed the order?
My lord. The order is at Annex
Child
2.
Welfare Committee.
Order is at Annex 2, my lord.
Under which section? Which provision of law? The child custody is always by the family court. What authority the Child Welfare Committee have got to decide adjudicate child custody?
My lord. It's my lord, page Annex 2.
We cannot, you show under which provision of law, Mr. Mohanty, under which provision of law this report, is it report or order? What is this?
After inquiry,
What is
IWC,
I'm asking that one. Is it an order or report?
And this is an order, my lord.
Huh? What is the order?
And Annex 2, page 15 to 21. Ordering person is on page 21, my lord. Starting from page 20. In the writ petition, my lord.
page number 9 may kindly be seen, it will clarify.
Page 9.
Yes. It is order dated 1/3/2023.
By Child Welfare Commission.
Yes.
Is there any such act here? Any act is there in your state?
Yes, ma'am.
Which is that act? Under which act they have passed this? Huh?
The child welfare.
I'm asking what the status of statutory status of the committee.
My lord.
Under that provision, this committee has been constituted.
Which provision? Which act? Anybody on the family court side in the local bar? Mr. G, any child welfare actions?
Juvenile Justice Act.
Juvenile Justice Act. Does not refer to any section. You just study and come back. All this matter.
Copy, sir, because
You copy.
I'm saying it from the board.
Also, you copy. You have to say under which provision of the act this order is.
Under constitution of the committee and power.
Called in the third week of January 2026. So that the FAR would come with more preparation to answer all possible questions. Yes.
Item 73.
My lords, item 73. This is a CMAPL for restoration of the FAO dismissed for default. My lords, I have filed IA number 516.
Any delay?
Yes, my lords. Yeah, there is a defect. There is a peremptory order to remove the defect. That is why
One is for restoration, another for condonation of delay.
My lord.
Two applications.
My lord.
A coordinate bench of the court. While order dated?
Order dated 3/3/2023.
3/3/2023 and dismissed the matter with
A dismissal on 5/4/2023.
5/4/23 had passed a peremptory order of dismissal. First, an application is moved seeking record of the said order. First, since there is a delay in making the said application to come, another application is moved seeking delay of condonation of delay of 522 days. First, both applications are supported by affidavit. Affidavits are filed.
My lord.
First, ordinarily, the litigant cannot be denied access to justice by orders of the kind. First, no prejudice should be caused to anyone. None. If dismissal order is recalled and matter is restored to the board, so that it would be heard on merits in accordance with law. First, anything in variance would be injustice. First, in the above circumstances, IA number so and so is allowed and delay is condoned. First, application in IA number so and so is allowed and order dated so and so is recalled, and as a result, main matter is restored to the board for consideration afresh. Post in first week of February.
May I please 1 minute in this case? My lord, in this case, the order was passed way back in 2017, your lordship.
No, they said 2020.
No, that's what I'm saying, your lordship. Original order of the tribunal was in the year 2017, your lordship. And against that, they filed an FO, did nothing. And in the year 2023, I got it listed and they were noticed to remove the defect. They didn't remove the defect. After that, there was an execution case filed in the tribunal, your lordship. In the year 2023, after 14 dates, they took 14 dates to comply with the order. When the tribunal to give them the last chance to comply, that is on 6/11/2024, they are coming in appeal.
Main matter.
And that matter has also been
settled. 2,000 rupees cost.
Matter has been settled by the apex court also as well.
The applicant shall pay a sum of rupees 2,500 to the OP.
OP number 1.
What we call that? Respond number 1. Respond number 1. Within 2 weeks, failing which the recalled order shall revive like phoenix. Within 2 weeks, you have to pay. Otherwise, the application.
My lord, since there is a holiday, there will be holiday.
4 weeks.
Item 74 has been.
Because I brought a wrong file, my lord.
You have brought wrong file.
Objection, my lord.
You have not brought wrong lunch box.
Objection.
No,
Objection.
You want some?
after lunch. I'm just bringing my file.
This file objection.
I'm bringing my file, my lord, after lunch. After lunch.
Yes, ma'am.
Which one?
Item
33.
74.
74. 74 is adjourned.
So I made a mention on my mention, it's listed.
Adjourned. It has been adjourned.
So after lunch.
Yes, to adjournment date.
First week of February.
No, I am for the petitioner, he is for the opposite party. Nobody can ask for that.
Unless you pass an order.
After lunch.
Item 75.
My lord, there are 2 IH, 14329 at flag A. I have received the copy just now. My learned friend has handed over me. For
February. First week of February.
First week of January sometime.
Third week of January.
This there is another IA, my lord, but for impleading parties, because they are going to be affected, so they are necessary parties. I have impleaded notice to go to them.
Issue emergent notice on IA number
5082 of 2025.
First. Quality, third week of January.
My lord, I put it in January.
Yes.
Item 76.
Yes, I have continuation 2004. Not regular. I retired within 9 months of the retirement. I have not regular till for last 21 years. That's why I filed a biscuit for any disposal of the matter. The third round litigation. Continuation 2004. Third round litigation. Continuation 2004 as Shikhya till date, my lord. But that is not.
Your request was rejected.
Yes, they are twice my directed to consider, twice they are rejected.
On what ground it is rejected?
They rejected on the ground that because you have been appointed, excess the vacancy. So, as per order of this court,
That
my case is that I was against 11th of 2007. Pursuant to order of government. Government directed to give 3 chances. In second chance, I succeeded. But they did not allow me to, they did not issue any fresh appointment order.
Your lordship,
Now they said
a date for hearing.
Because of
First week of February 26.
Final discipline.
Yes.
My lord.
Item 77 has been adjourned. Item 78.
Indeed, I have filed IA for interview.
I have not received intervention copy, though I am the petitioner counsel. Give. Yes, whose copy?
2 minutes. I am
He is also entitled to a copy.
Okay, one clearest copy I will provide today in the course of the day.
We'll call in the third week of January.
Yes.
Stop.
Item 79.
79, my lord. I'm sorry, my lord, my mistake. Because it's a dispose of case. Another matter is pending on behalf of this person. And I filed a memo for listing of that case, my lord.
This is posted. That matter to be posted. This is dispose of matter.
Dispose of matter, sir.
No orders are required.
No orders.
No further orders required in this matter, which is already disposed of. But you give memo that we'll post that matter also. Just write down it.
I'm giving that.
Take that memo. You one wait.
Item 80.
May I please, my lordship?
Yeah.
My lordship, on 12th only the order was issued not to process the
We have
legal
to
act.
file counter in this case. Lordship have issued notice on 12/12. We have to file counter sometime is
There is
necessary.
interim order now.
My lordship, interim order is there, my lordship, and on that day only the petitioner approached before the Tahsildar that already the interim order has passed, but Tahsildar did not accept the certified copy and he has issued. As per his version, he has issued the legal aid certificate. On that basis, I filed another
Same day
IA.
the certificate was issued.
Same day. And on that basis, I filed one IA, my lordship.
We shall file a counter in this case. So that
I filed a IA, my lordship, to revert or revoke the legal aid certificate.
Call into a week of February 20. Next week. That's the request of in the being with obligation. Wait, counter effectively. Yes, next.
Item 81.
Prevention of cruelty
Yes, my lord.
to the judge.
If my lord would, my lord would recollect, on the last date of hearing, my lords had just taken an overview of the matter. So, my lords, the issue in this case before my lords is that the petitioner is claiming for statutory dues for having kept the animals which were seized by the police and handed over to me, being a Goshala, registered society.
Registered society.
My lords, registered society.
Society under the Society Registration Act.
Yes, my lords, registered under the society registration.
How many cattle when?
My lords, the seizure total was 388.
Slaughtered.
My lords.
They were sought to be slaughtered.
They were sought to be slaughtered, my lords. Maybe state would be in a better position to say. I can only point out the sections under which the FIR was registered. My lords, this is 388 cattle which were seized by the police.
388 cattle.
My lords.
When the seizure took place?
My lords, 13th of October 2019. And the FIR number 83.
12 October 20.
Very well, ma'am. So 12th, I'm sorry, my lords, I stand corrected. 12th October they were seized. 13th October handed over to me.
FIR number?
Well, it's 83 of 2019. Under section.
Offense is punishable under?
My lords, 379, 411, my lords, 411, 427, 429, 34 IPC and section 11 of the Prevention of Cruelty. And my lords, also 6 and 7 of Odisha Cow Slaughter, Prevention of Cow Slaughter Act. 1960 minutes.
Which page you are reading from?
My lords, this is PDF page 93.
Orissa Cow Slaughter Prohibition. Which is that act?
My lords, this is State Act, my lords.
Orissa?
In our compilation, which we had submitted before my lords after the last date of hearing.
That's right.
It is.
No, there was the compilation. Yeah, given the act also given to me. I owe an apology to you that I could not go through the books which were furnished to me.
No problem, my lords. We'll try our best to assist my lords to the best of our competence.
Yeah.
And we'll try and answer whatever questions my lord has.
They were given on which date? 13th, you were interested.
13th of October, 2019. And if my lords may, if I may just request my lords to come to running page 24 and the PDF page 93. That is the letter in terms of which the custody was handed over. Page 24, my lords, may I read?
They paid,
24, my lords.
The receipt.
No, my lords. It's a requisition to provide shelter to the seized cattle. May I read? Sent by the IIC, my lords, who was the inspector in charge, Nihal Prasad, PS. To address to the president, if I may just read, my lords.
Provide shelter to.
Yes, my lords. With reference to the case and subject.
Yeah.
May I, my lords?
Yes, sir, you went to. You were requested to.
Yes, my lords. So we were requested, and my lords may also just see the last page, last para, which says, hence it is requested to provide shelter and the necessary funds will be provided for their care and maintenance by the district administration. So this was an assurance given to me.
Yes, brother.
At that stage.
Milord, on the last occasion, Mallas has directed to take instruction whether the payment which has been made and the residual amount, it is to be paid within what time and what will be the fund. On being contacted, Malord, out of 388 cattle, 162 number of cattle is being handed over to the society.
Admittedly, my lords.
It is not disputed, my lord.
Not 388.
Admitted. 388 was seized, my lord.
Seized.
Yes, but 40 died. Out of that, 41 died. 162 handed over to me. It's an admitted situation, my lord.
152.
Yes, that's an admitted situation.
And some part of this amount has already been paid. This is also not disputed. But on query,
what is the amount received?
My lords, we had given a calculation sheet.
Milord,
Tell us how much money you have received.
the remittance of amount.
What we have received up till now is, my lords,
May
I just place the calculation
For a moment,
sheet, my lords, which we had placed.
Just asking you, how much money you have received? I don't need that calculation.
I'm giving the
4,86,000 at one instance.
Oh, totally, I'm asking you. How much money you have received?
I'll just take 1 minute. my lords.
You tell that now. Figure.
I'm giving the figure. As I have been received. 736.
72.
7,36,000.
But 2,86,000.
Yes, ma'am. But I ascertained.
7,36,000.
7,36,000.
My lords, the calculation sheet is, if I may just request my lords to come to PDF page 360.
Paid by bank checks. Just
My lord, let me clarify one aspect. When I ascertained what is the reason that you are disbursing nor taking of the care of these cows and cattle, which you should be.
No, you say.
My lord, just one second indulgence, my lords.
Did you pay that money?
Yes, my lord. That is the details given. That will be given Sri Gopal Gosala, IFC code, account number.
How much money you have paid?
It is, my lord, rupees 72,86,221.
I'm instructed to say that this is a different case. This is with respect to 24 cattle, which is a different case altogether, which was given pursuant to a contempt proceedings initiated, and this is not the same FIR as I'm placing before my lords. This is made by Ankur Collector, my lords. The document says.
No, this is Ankur Collector. But one way, the another party.
Clarity first.
Yes, man. Another party.
Payment, no, not another. Your contention that you have made a payment pursuant to this case is not true. Let us be clear on facts.
Yes, ma'am. But so far the payment is concerned.
FIR number 83, FIR number 83 of 2019.
Yes.
388 cattle were seized. Out of them, many died. Well, 162 cattle were given to the
handed over to the
this. Where is the payment made?
My lord, can I have a glance to A by 1? Well, page 8 to my counter affidavit.
Your counter affidavit.
Yes, ma'am.
Which is that annexer?
This is at annexer A by 1, page 8, ma'am.
To page 8.
Yes.
That becomes 67.
No, ma'am. This is in
Branch
first page,
manager,
it is 1 lakh.
Denkanal.
Yes.
That one?
Yes, ma'am. Honorary Secretary, DRCB, Denkanal, ma'am.
How much money have been?
This was in first page, it is 1 lakh, ma'am.
1 lakh.
Then subsequently in D by 3 kind of
Wait,
a
not now. I am asking you, don't make Red Court a calculator.
total
I am
amount.
asking you, how much money you have paid? Admittedly, how much money is paid to you, madam?
My lords, 7,36,000 total money.
During what period it is paid?
Yes, it is paid in 3 tranches.
RTGS. By checks.
RTGS.
Yes.
How much money is payable? What is the yardstick for the payment?
My lords, it's a prescribed rate, my lords. Its rate is prescribed, my lord, which is 200 rupees per cattle per day. And these are, my lords, the guidelines which were given, which are adopted by this state. And it's an admitted case that this is the rate prescribed. I'll point out from their documents itself that there's no dispute with regard to the amount which is prescribed.
My lord, there are 2 rates, ma'am. One is the central government, in the state government, it is much less, ma'am. Keeping in
state government. But you have paid it at the rate of 200 only. At the rate of 200 only you have paid that.
200 million. We have paid it in 200 million. And they have been paid 7,20,000.
For how many days? How so simple a matter. Yes. An 8th student will be able to do this. How many cattle? How many days?
And what will be the quantum?
That quantum. How much you have paid? How much to be paid? Case is over.
Yes.
Answer.
And what will be the rate, my lord? Because that rate varies.
Anyway, you have paid 200 rupees. Even according to you have paid at the rate of 200 rupees. Anyway, according to you, what is the rate?
Well, the details, instruction may take.
Madam have come all the way from.
My lord, even if in BC, my lord, it will be on Monday. I don't pray for a long.
No, at 2 o'clock we have that. Call your officer.
My lord, I have tried my level best. In the meantime, collector CDB has been changed. I have tried my level best to make it contact. At least 2 days, be it Friday or Monday. By that, I will come prepared. What will be the quantum is to be disbursed?
My friend is in.
Welcome to this state.
I'm so grateful.
That will be held up in the court. I understand.
Yeah.
Therefore, you can argue.
BC, my lord, in BC. We are ready to cooperate.
Simple matter.
Just one respectful submission, my lords. My friend is in difficulty. No problem with that, my lords. I understand. I've been a counsel for the state too. My only submission is, my lords, the calculation sheet which I'm relying upon, which was filed by us long back, my lords. So it was not that notice available to my friend was not enough. The time available, I will not object to something like this, but just respectful submission that the state can be little more.
Monday, Monday. By that, it will be easier me to file an affidavit on what basis and what will the quantum and what is the residual amount which is to be paid.
I will make an order.
Yes, ma'am.
My lords, the instructions may be taken till date, my lords, because
date you have to make it.
Yes.
Okay. As many as 388 cattle were seized pursuant to FIR number 83 of 2019. Inter alia for offences punishable under the Prevention of Cruelty to Animals Act and the State Act as well. Of these, 162 came to be entrusted to petitioner society wide on 13/10/2019. Go to page 93.
Annexure 1. Annexure 1.
Pursuant to Annexure 1. With the assurance that payment would be made for sheltering the sick person. Learned senior advocate appearing for the petitioner, Madam so and so, fairly submits that as of now, a sum of rupees 7,36,000 has been remitted by 3 RTGS means, and that totally a sum of rupees.
And it's 7,36,000.
No, that is all right. What is payable?
What is payable? No, it is 7 point. This part still has to be determined, but as per the calculation sheet which was submitted before my lords in 2023, manage, it was the outstanding at that stage was rupees 3.86 crores.
3.86 crores.
Yes.
What is the value of the cattle for 162 cattle?
162 cattle, my lord. Look at the period, my lords. They were given to me in 2019. We are in 2025 today. And it's a case property, my lords, and state is.
Let that amount which has been disbursed, 7 lakh somewhat, that be there. With all details, I will come prepared and file this application.
Concern for the senior advocate submits that crores, money in crores is due for sheltering the cattle on these years. And therefore, without any justification, the same has been withheld, despite giving the calculations way back in the year 2022.
Yes, 2023, my lord. 13th of February, 2020.
February. First. Learned AGA appearing for the OPs seeks a short accommodation to comfort his clients and come back. First, call on Monday.
With respect, may I just make one suggestion? Since my friend has been fair enough to admit that there's no dispute with regard to the rate, which is 200 per cattle per day.
No, he disputes that also.
I thought
My lord, difference of the state and the central the amount. That I will come prepared, my lord, whatever the amount is due. And last occasion on the discussion also.
Not only come prepared, whatever amount according to you, that DD you have to bring.
Yes.
For disputed,
Then obviously. But the admitted amount should be paid at the earliest.
the admitted amount due shall be paid to the petitioner on the next date of hearing.
Paid, let me come with the instruction and the
Admitted amount. Whatever is admitted by you.
Admitted, if I may just please. This was admitted way back in 2020.
No,
22, my lords. Their affidavit of the state, where they say the petitioner is entitled to receive an amount of rupees 76,27,634. This is what the state has said. So let them be fair at least to that extent, my lords.
It's your affidavit, Mr.
Yes.
Monty.
Yes,
In
my
your
lord.
affidavit, you have admitted the amount.
Whatever admitted amount, my lord, I am coming.
So my friend may take instruction even on that, my lord.
Admitted to be paid.
I will take the
Amount admitted to be due in terms of affidavit dated.
This is my lord, 16 lakhs 20,900.
This was an IA filed by them, which is IA number 12999 of 2022.
In the AA filed by the OPs.
The date has my lord is 19th September 2020.
Shall be remitted to the petitioner on or before the next date of hearing. I will call this matter in the first week of January, so that in the meanwhile let them bring the money. Otherwise they will say very difficult this, that, etc.
Well, if my friend can at least take instruction and come back on Monday, at least some clarity.
Come before
Oh, very well, my lords. Then my lords may my lords. Then my lords may hear it as convenient to my lords. My lords, and let it be before my lords.
No.
Item 82.
Yeah.
Item 82.
May it please your lordship. My lord, the petitioner is 72 years old. My lord, claiming promotion from the date his junior has got. My lord, without disturbing his after yes, yes, ma'am.
25 let notice notice let it be disposed of.
25?
Yes.
Sir, this is that 25. Give that
25. Let it be disposed of with similar direction.
Instead of notice disposal in terms of this order.
Yes.
You have changed the
Yes.
covered by judgment.
Yes. Obliged.
24. We should notice in that.
Yes.
So instead of that, now it should be.
Sorry for that.
Sir.
66, my lord. My lord, I directed nearby any vacancies. So right now I could not get the. Can I take tomorrow or day after tomorrow? It will be convenient.
Tomorrow. Day after tomorrow.
Day after tomorrow it will be.
Monday I will also take instruction, but I have telephone.
Then I will take from the government side, my lord.
From my side.
Let it be on
Monday.
Friday, my lord. Let it be on Friday.
Monday.
Why Monday? You want a phone call? You can please call it on Friday. Yes, next.
Item 74.
74. I pray Russian call it tomorrow.
No, my lord, my lord.
Tomorrow. Which year matter?
2024. My lord, only limited grievance and this can be disposed of, my lord. This can be disposed of because opposite party 6 filed an affidavit. My only grievance, the governing body, they are not reconstituting. So if they now opposite party 6 filed an affidavit in para 11 and para 12, they said that we have already submitted proposal pending before the director. If my lord dispose of director has to take a decision, that can be. My lord, can you see the affidavit para 11, para 12? They have said that proposal has been.
Petition prayer deeds has well.
Para 11, para 12 can you see?
Next, correct. Lord Council appearing for the petitioner point out paragraphs 11 and 12 of
affidavit filed by OP6.
Affidavit filed by OP6.
My lord, kindly see my lord.
Read that and next paragraph. There is a unanimity at the bar that petition can be disposed of with a direction to OP number 6.
OP2, director. Director has seconded.
To take a decision on the proposal submitted by
OP6. So OP6, my lord.
OP number 6. 6.
Within a stipulate.
Within a reasonable period.
For approval of the
for the purpose of
approval of the
for considering proposal for approval
of the governing
body. Within a period of 6 weeks. 6 weeks. Ordered accordingly and writ petition is disposed. These two paragraphs you have to.
It is open for the parties if any person agreed.
All contentions are kept. Next.
Item 84 was adjourned to take
So 84.
Item 84.
Yes, which matter?
84 is that's a matter. First case I am appearing, my senior friend is appearing the second matter.
Yes.
Point is very limited, which has been already resolved by the Supreme Court. Of course, you also ask that question to my friend that it is covered or not. Take instruction. He said subsequently it is not covered. That is why I also wanted to argue matters. You know, date chart I prepared. There's one of the writ application which has been transferred. It has got a copy to this. This one is court. I am giving a copy. It has said a court copy of this copy. Sure. 29/12/1993, subject to my non-friend kindly permit me himself. Basic, all right. 19/12/93, National Council of Teacher Education Act 1993 came into force. Section 29 of the Act provides for binding effect of the direction on the question of policy of the central government on the NCT. The 9/8/2017, the Right to Children to Free and Compulsory Education Amendment Act 2017 came into force.
and the following proviso was inserted to section 23. Provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right.
Just amendment.
Right, sir, right, 2017. Then 22/9/2017, it is very important, which has been given much emphasized by the Supreme Court. The NCT, in view of the direction of the Human Resource Department under Section 29 of the NCT Act 1993, and after considering the recommendation of the expert committee, the chairman, NCT, in exercise of the power under clause 12 of the NCT Recognition Norms and Procedure Regulation 2014, was pleased to grant relaxation on the direction of DLED ODL program for in-service untrained teachers who reduce it to 18 months instead of 2 years. That's a market through ODL mode, and the requirement of 6-month internship was
earlier it was 2 years.
18 months program. That is Annexure 2. Before I take your worship to the other date events, you also look to that Annexure 2. That is the that is the crux of the matters. 2017 at page 224. That is issued by National Council of.
No, what has happened actually? You give me the brief.
Sir, what has happened? These petitioners, they are the in-service candidates as on 2017, and they have completed 18 months of training as a training from 17 to 2019. Now the whole question for consideration is the NCT order, that circular, which was issued by the NCT in 2017 in terms of Section 29 consultation with central government. So whether they will be covered by that or not, that is the only question.
According to you, they are covered.
They are squarely covered by the judgment of the Supreme Court also, because various.
Covered for what purpose?
Covered for the purpose of getting selection and appointment. Getting selection appointment. Just I'm taking your worship straightway to this circular. Then I'll take your worship to the judgment. That will, I think, for your worships, I need not go to other things. Sir, you also look to page 24. Page 24.
Recognition order.
Yes, sir. This is National Council of Teacher Education. Recognition order dated also look to 22 September 2017. By 22 September 2017. I'm just reading that.
One second.
Sorry, sir.
September 2017.
Yes, sir. Page 24, Annexure 2.
The recognition order means a recognition issued to any particular individual.
No.
Policy matter.
Policy matter. Yeah, policy matter. You also see to be published in the official gazette, that has been published. Whereas the matter of recognition of the project proposal of National Institute of Open Schooling, NIOS, Noida, for DALED, ODL, that is called ODL, program through SWAM proposal and so training of in-service untrained teacher was considered by NRC and NRC oversight as follows. And whereas
relevant.
Just next line, sir. And whereas the NCT has received direction under Section 29 of the NCT Act from the Minister of Human Resource Development Department, that is once. Relevant is the last but one paragraph. And whereas in view of the mentioned direction of the Minister of Human Resource Development under Section 29 of the NCT Act, and after considering the recommendation of the expert committee, Chairperson NCT in exercise of its power under Clause 12 of the NCT Recognition Norms and Procedure Regulation 2014, granted relaxation to guide NCT headquarters letter NCT dated 21/9/2017 and 22/9/2017 to the following provision in the NCT Regulation 2014 for ensuring that the directive of the MHRD for implementing the amendment of the RD Act 2009 are duly fulfilled. One. The amendment which just now I've read, the 2017 amendment. Any provision related to online submission of the application of NCT application portal. 2. Any provision related to duration of the program so as to reduce it to 18 months instead of 2 years, and the requirement of 6-month internship to be subsumed within within the duration of 18 months. Then next page.
Means what?
Yes, page 25.
No, what is meant by Q?
Yes, sir. Then for EQP, it was the duration program, it will be reduced to 18 months instead of 2 years. You can also look to that.
That would include internship also.
Yes. That is.
Within that.
There is no requirement of 6 months internship.
That is
how 18 months is brought down.
Yes.
Otherwise, it will be defeated.
Right, sir. Sir, kindly look to page 25. Why this was made, blood? Just page 25. Let's look to page 25. Whereas, after having considered all the above facts and figures, the NRC considered the case in its 275 meeting, the part 3 decided that recognition be granted to National Institute of Open Schooling.
Come to item number 1.
Yes, the duration, yes, that's correct.
Duration of the
same program shall be 18 months instead of 2 years.
Including 6 months internship.
As you are right. And this has been done because of that 2017 amendment. You also look
RTE amendment.
Yes, RTE amendment. They said that grace period also look to that 2 years.
That explain that gave 3 years.
Nice. Say that
31, 3 to 4 years.
4 years.
4 years.
Yes.
4 years.
Provided further that every teacher, this came into force on 9th August 2017, provided further that every teacher appointed or in position, we are appointed earlier, as on the 31st March 2015, who does not possess the minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 4 years from the date of commencement of the right of children to free and compulsory education amendment.
That is August 2017.
That came into 9th.
The 4 years would end on 31st March 2019.
Because the cutoff date is 31st March 15. So
Within 4 years.
Within 4 years.
31 March 2019.
Yes. Now you also straight away, according to me, let's come to the judgment. That judgment I have enclosed.
No, what is their version? Their version is.
Sir, I'm coming. They are saying they are referring to a review order. I'll just pick just 2-3 minutes. Kindly come to that judgment. That will solve the entire purpose. That is for your lordships to take a decision in terms of that judgment. Page 80. Page 80.
In Jaivir Singh.
Yes, sir. Yes, sir. Then you also kindly come to. Yes. You also come to page, what is the relevant portion? 4.6 to 4.10, then I'll take your also to relevant portion. In view of the provision, 84, running page 84. Yes, sir. Yes, yes, sir. In view of the provision, second provision to subsection 2 of section 23 of the RT Act, MHRD issued a letter on 3rd August 2017 to all the secretaries of the state and union territory directing that all the teachers in the government school must possess minimum qualification.
As per IIT Act.
Sir. Then, sir, kindly come to 4.7. NCT issued a recognition order 22 September 2017, which just now I placed people on it, thereby conducting DLED program through ODL mode by NIOC OS through the some portion of MRC for in-service untrained teacher at elementary level working in government aided and unaided private schools. The said recognition order also reduced duration of diploma from 2 years to 18 months. Then, sir, para 4.10, it appears that High Court of Patna has passed a judgment on 21st August, January 2012 in the case of Sanjay Swanshaw, holding that the Director of Primary Education NCT has illegally issued a direction that the person who had obtained DLT course for 18 months by NIOS
not
eligible for appointment on the post of teacher in primary. It held that said direction of the Director of Primary Education was issued on misrepresentation and misreading of the
Tripura High Court also took the same.
Sir, then paragraph 23. Kindly come to paragraph 20. That is at page 89. Page 89.
Paragraph
23.
It is thus clear.
Sir, it is thus clear that all such teachers working in either government aided, unaided private schools were required to acquire the minimum qualification by 31st March 2019, or they would face dismissal from service. It appears that it was decided by the central government to provide a window.
Dismissal from service?
Yes.
Removal from service?
Removal. The difference between removal and dismissal. That's right. It appears that it was decided by the central government to provide a window for all such teachers in service and that 18 months. A perusal of the said communication would reveal that various directions were issued so that lakhs of teachers who were untrained get the requisite qualification prior to 1st April 2019. The communication addressed by the Director of Elementary Education Uttarakhand dated 8 September 2017 to the Chief Education Officer and District Education Officer would further clarify this position. Then the page 24, that's 22nd September 2017, I have already placed before Lordship, that has been quoted.
Yeah.
Yes. Then sir, kindly come to para 25. Next page, page 90, para 25. It is thus clear that the said recognition order was issued so that the directives of MHRD for implementing the 2017 Amendment Act duly fulfilled. It appears that since the time gap between the direction issued by the MHRD and 31st March 2019 was only about 18 months, the period of course was reduced from 2 years to 18 months. This position would be clarified from the said recognition order itself, which reads thus, any provision that you have already read that. Para 28.
Yeah.
It can thus clearly be seen that as on 6 September 2019, it is also the view of the NCT that minimum qualification for appointment of teachers for class 1 to class 8 is a 2 years diploma in elementary education. It further clarifies that NCT recognition order dated 22nd September 2017 was only for those untrained in service teachers, that's a market, in government aided, unaided private schools who were appointed on or before 10th August 2017. It further clarifies that for fresh appointment of teachers for primary and upper primary level, NCT notification 23rd August 2010 and 29 July 2011 need to be strictly adhered to. It is further to be noted that whereas notification is also skip over. Then para 29. It is thus clear that the entire scheme was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to 1st April 2019, they could not have continued to remain in service and would have faced dismissal from service. As such, we find that the High Court has erred in holding that 18 months diploma conducted by NIOC through ODL mode is equivalent to the 2 years diploma as provided in notification of NC dated 23 August 2010 and 29 July 2000. That for the fresh candidate, that the question is whether equivalent or not. But so far the window, one window which was...
this is for inside.
Yes, sir. That is exactly. That is only case, sir. Para 31, sir. We find that High Court of Patna has totally erred in not giving effect to the stand of the NCT. As a matter of fact, we fail to understand as to why NCT did not challenge the said order when its specific standard that the said 18-month course was only for in-service candidates and not applicable to fresh ones.
For them 2 years only.
That's sir. Then sir, kindly come to para 35 at page 93. Para 35, page 93. As already discussed here in above, NCT recognition order dated 22nd September 2017 was issued so as to give effect to the directive of MHRD dated 8 September 2017 so as to provide a one-time window to the teacher who were already working and who in terms of 2017 Amendment Act required to acquire the minimum qualification prior to 1st April 2019. The said order in any case cannot be held to be a direction to the state of Uttarakhand to act in contravention to 2012 service rules and the advertisement. Then you also kindly come to para 41, which is the concluding paragraph. Page 95, para 41. In view, let's get it. Yes. In view of what has been held by this court herein above, we find that High Court erred in holding that 18-month diploma conducted by NIOS through ODL mode is equivalent to 2 years regular diploma, particularly so when there was no material placed on record to even remotely hold that such a qualification was recommended by expert body NCT. On the contrary, this is important. The communication dated 6 September 2019 of NCT, the directive of MHRD, so also the recognition order dated 22nd September 2017 clearly go to show that 18-month diploma was provided as a one-time window to the in-service teacher to acquire the minimum qualification between the 2017 Amendment Act and the outer limit of 1st April 2019.
In other words, this reduction from 2 years to 18 months, 1.5 years, is only for those in-service candidates who were there as on August 2015.
The
15. Because 4 years from that day.
Right, sir.
Okay. So the concession given to in-service candidates is a one-time measure.
One time, yes.
Okay, it's a concession.
That's it.
Perhaps they did not want lakhs of people.
Relaxation in terms of section 29. Yes.
Right.
Yes.
That up to that I have understood.
Sir, that is
not applicable to fresh candidates.
No, not at all. That is
up to this I have understood.
Sir.
Now what is the grievance?
Sir, page 96. Just concluding that judgment. Page 96 and 3 lines in paragraph 42.
As already discussed. The impugned judgments of that Uttarakhand.
As already known, that paragraph 42 as already discussed here in above, recognition order dated 22nd September 2007. Para 42 at page 96, just above para 43. As already discussed. Second line.
Yeah.
As already discussed here in above, recognition order dated 22nd September 2017 only provides a window for in-service teachers to complete their course prior to 1st April 2009. Is that what your lordship said? Yeah. Now, your lordship look to the in fact, while the batch of writ applications were filed before lordships, in fact, I have given that copies in my rejoinder.
Why are you here before the court?
Yes, sir. What they have done is page 42.
Next 7.
Page 42.
Notification.
Yes, sir.
Page 41 is in there.
This notification is issued by whom?
Issued by the Orissa
State government.
State government. And if your lordship will come to page 44, that is a part of that one. Page 44. This is the cause of action. This is on 16/1/2024, para 5. Candidates, let's get it.
Applied with qualification of
18-month DLED course from 2017 to 19 through ODL form, NOSU will not
be entertained.
This is the cause of action. Rejection order, let's see, that is at page
Annexure 14. Relevant page is page 7.
What it says? Candidate
applied with qualification of 18-month DLED course from 2017 to 2019 through ODL from NIOS will not be entered.
Why that situation arises here?
Because they say the judgment of the Supreme Court was misinterpreted as if.
No, question is, this is for, if notification is for what? Fresh appointment.
Fresh appointment.
Fresh appointment.
This was, they are selected, petitions were selected, they are directed to be present for document verification. But during document verification, they said that
they issued this notification.
Yes, that is at page 44.
Your contention is it runs counter to the judgment of
the Supreme. Nice. And
what happened in review?
Just I'll show you. The review application was made IDC
by the state,
not by the state, by some candidates
of other states.
You also other states. You also look to that page 97. Page 97. At page 98. May I read this?
1 second. That notification is why that notification came to be issued by the state programming authority.
That judgment, because the Supreme Court judgment was pronounced on 28/11/23.
28/11/2023.
And the advertisement was issued on 10/9/23.
But you were all in-service candidates.
Yes. Yes, sir.
Where is the question of outgoing?
They misinterpreted
Fresh, as if they interpreted these candidates because they have acquired this 18 months, even if they are in service, but they are treated as a press one.
They are records as a whole
It is they said that wholly it is not applicable at all. You will also look to page 98. In fact, what has happened, some cases which are transferred, about I'll show that I've enclosed that document. 19 candidates, they had also approached this Hon'Ble Court with the self-same prayer, just like this very same advertisement. That was somehow in other cases which were pending before the Supreme Court, that was called for, file. And that was disposed of, directing that to give appointment to them. That has been also listed. That is also directed, that has come also.
Now appointment orders are not issued to you people.
No, because we also have passed interim order keeping reserve posts. Because they have been selected, but because of this reason only the rejection order is at the page.
Annexure 14 page.
So what is meant by in-service candidate?
That has been also said. In-service candidate means as an untrained teacher, they have been appointed in a aided government or private school.
You are already appointed.
Yes, sir.
You are in.
That also have influenced those requirements.
Once again, I want to get clarification. Sure. Law I have understood now, subject to what other side will say. Now you are already in service.
In service is that in
private school, sir.
In private school. You wanted to come to government service.
Yes, sir. This in fact, in the date chart I have given, that advertisement was made for appointment of junior teachers in various schools. And in that, pursuant that we applied. And in fact, they entertained our application. But subsequently, they said that your application cannot be entertained because you have acquired this 18 months.
That MHRD circular intentionally to protect the in-service candidates. Wherever they were employed, from there they will not be removed. Though Supreme Court uses the word dismissal, may not be dismissal at all because it is a simple dismissal. It is removal simpliciter because you do not have requisite qualification. Okay, but for fresh appointment, this should be treated. Where is the observation of the Supreme Court?
That is that paragraph 43. It
is only saving the employment which you have already gained.
No, that is there.
But if you leave the employment portal here and want to go to some other portal, then the 2 year is required.
That's right. That 2 years is required for the press candidates, for the pressers. That is what the Supreme Court has said.
Therefore, I ask you what is meant by in-service candidates. The object is not to give employment to you. The object is that you should not lose the employment which you are already in. The object of August 2017 amendment to RTN, it required a particular qualification. Those who do not have, that they could have done it within 4 years. Those who do not have, for them, they ran the risk of removal. They ran the risk of removal. Therefore, the MHRD issued that particular directive. In terms of that, NCTE acted under Section 29 and made the particular provision. The object of the provision is to protect you from removal in the employment in which you are already there. The object, see, I am on head-on's rule. In head-on's rule, House of Lords said, perhaps you may be aware of the facts, where the law required fencing of the vessels which carried the sheep in the Irish Sea. The object of the law was to prevent the spreading of disease from one herd of sheep to other, going in other sheep. Then because of the tidal action in the Irish Sea, perhaps you might have seen Irish Sea is not that smooth, the sheep were washed away. And action was brought by the cargo owner. Had you complied with this rule, our sheep would have been saved. Therefore, I should be given the debts. Law required that. House of Lords rejected it on the ground that the object of the law was not against your sheep being washed away by the tidal action, but to prevent the spread of the disease. If that rule is kept in way, how are you going to derive milk from this judgment?
Let's look to the review judgment.
Review judgment, paragraph 3 probably clarify answers.
Page 26 of the notification.
Which is that review judgment?
That page 90.
Annexure 18.
Page 98. Page 90.
What is the review?
There are some, the grievance sought to be, may I place it? The grievance sought to be raised on behalf of the review petitioner and some of the applicants before this court is that though they are in employment and covered by the recognition order dated 22/9/2000, they believe that the judgment and order dated 28/1/2000 would come in their way if they want to make better their prospects by applying either in other institution or for promotional revenues. Has your lordship got it? Then they say that we have already clarified, so it doesn't require any review. But paragraph 3, however,
kindly read paragraph 2 again.
We have already
read once again, paragraph 1.
The grievance sought to be raised on behalf of the review petitioner and some of the applicants before this court is that though they were in employment and covered by the recognition order dated 22/9/2017, they believe that the judgment and order of this court dated 28/1/2023. 2011. That is the judgment placed by my lord and friend before your lordship would come in their way if they want to make better their prospects by applying either in other institutions or for promotional avenues. Then Lord, paragraph 3.
We have already
clarified in the judgment under the review that the one-time scheme was provided solely to
safeguard the interest of
those teachers who are employed as on 10/8/2017. We are therefore not inclined to entertain the present review petition as well as miscellaneous application. Then paragraph 3 is important. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017 and who would have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions. Has your lordship got it? Or for promotional avenue. So we applied
as good as 2 years.
Yes.
As good as 2 years.
Yes. Then my lord friend was stating, he left halfway below. Some of the petition, but
kindly see that next paragraph.
Yes, needless to say that the date of pronouncement of the
clarification will be effective from the date of pronouncement of the judgment from the date of judgment.
So, my learned friend
in other words, even when you leave that employment in a private school and stake your claim for employment in public school, even then you should be held to be qualified.
Obliged. This is certain. Then another feature is that some persons similarly placed like that of the petitioner also approached this Hon'Ble High Court like us. Their cases were transferred to the
Apex Court. They were withdrawn to the Apex Court.
Apex Court directed that since they have 18 months and they are eligible and they are been selected, so give them appointment directly. That is,
we will also look to page 28 of the rejoinder and giving that copies everything.
Where are those judgments which you say?
That I have enclosed. I have enclosed the rejoinder in my case. Page 28, annexure 21.
into the
Yeah.
Will your worship look to page 28 of that rejoinder, annexure 21. The order of the Honorable Supreme Court. Let's get it. Let's look to TPC number 1052 and 1404 of 25. Let's get it. That middle, para 3. Hence, the transfer applications are disposed of or withdrawn. Then let's skip over to next page.
Yeah.
The sole ground, para 3, the sole ground on which they were denied appointment.
Yes, I have seen that. Did not possess the diploma.
Yes. Then, in that view of the matter, the transfer petitioner allowed the respondent state are directed to issue appointment to the petitioner within a period of 3 months. Then they also look to the page 31. Name of the coach board, Amar case to that.
Okay.
This 1052, if you also
that is also fresh appointment only.
Sir. The same advertisement, same.
Well, the very same advertisement.
Yes, sir. Sir, also look to that. I've given the copy of the writ application. That is at page 37. Page 37. This is the writ application which has been transferred on the college. And you also have called for that writ petition file also.
The last case in the
list. The prayer was the same, exactly the same prayer. WPC also kindly look to that file is there. WPC 13853 of 2025.
Anyway, you say that the very same advertisement.
Same advertisement, same prayer.
The apex court directed to grant
give them the appointment.
Actually, this whole ground was that they possessed to do.
And they have been given appointment also.
That I don't know. It is in the process.
Any other point, brother? You want to say anything? You want to add? Don't repeat anything.
I
have nothing to say.
I am relying upon the circular.
What is that?
Circular, I was pointing at page 26 of the circular, annexed to 2 minor.
No, that is considered very apex court.
There is that it is clearly been mentioned that appointment should be on or before 10th August 2017.
Yes.
So granted to their in service before to 10th August 2017. That has to be checked with all the expeditions whether they were in appointment while applying for the force on or before 10th August 2017.
Yes. That is rejoinder page 25. I have given the certificate.
Appointment orders. There is no dispute.
You are Union of India.
There is no dispute regarding them.
On that date of appointment, there is no dispute.
No.
All you are appointed before that cutoff date.
Yes.
Before cutoff date. That is 10/8/2015.
10/8/17.
10/8/17.
That resolutions.
That amendment.
Yes. They told that on 31st March 2015, from that date, within a period of 4 years, that is 31 March 2019, all the candidates have to fulfill
within that particular
from 31.
Because the notification came in 2017 and the 1st April 2019 was the cutoff date. There was no period for that 2 years.
18
that is why
your stand is those who are
appointed on or before 10th August 2017, they may be considered.
That is
they qualify for the.
there is no dispute. There is no dispute.
No, you are half party speaking. I do not know. What is qualify for what?
The candidates who were appointed on or before 10th August 2017, they come under the purview of the order of the Honorable Chief, come under the purview of the circular of the government.
Appointed where? It's circular.
NCT circular.
No, you are confusing me. Do you support the case of the arguments of these people or oppose the argument of these people?
And I support to that extent that the appointment should.
That you have
that part only.
So you are you cotton with those arguments. You agree with his arguments, their arguments. Subject to they being appointed during that particular period. In other words, if all they are appointed prior to that during that particular period, which will begin with effect from 10/8/2015.
31/3/2015 the starting date.
31/8/2021, therefore 4 years.
4 years, 31/3/19. So they have to complete prior to 1st April 2019. The amendment came into force in the month of 2017. So there was a period of 18 months.
So remaining period itself was 18 months, therefore they fixed 18 months.
Right.
In which the internship period, training period is also subsumed.
Yes.
6-month period is also.
That was the objective.
Home license.
And the other condition is
Let us see what they say. Yes, Mr. Leshwa.
For your lordship's convenience, I have also prepared a chart along with some citations also.
Before that, just clarification.
Yes.
You may argue in your own way. I will not come in that. Just I want to know.
Yes.
There is a direction by the apex court to give appointment to the candidates who are similarly circumstanced with the petitioners. Was there such a direction? You have seen that. They have read that direction.
Now, the petitioners were not in government service.
Petitioners were not, obviously.
Not
Had they been in government service, they would not have gone to come here at all.
And your lord, my learned friend has showed your lordship that paragraph 41 that is a for a one-time dispensation. The Honorable Supreme Court has directed to consider their case. But here,
but clarification in review,
the review was filed by some other person.
All right.
Though
The judgment is applicable.
They apprehended that they will be affected by that judgment.
No.
Yes. Your lordship see the.
Anyway, review judgment. Let us understand para 3.
Yes.
Read para 3 of the review judgment.
That will be given effect from 28 from the date of
the judgment. Itself.
And
what it says according to you. That is the jugular vein of the case.
Yes, sir.
Read para 3. Para 2 gives an impression which runs with your assumed stand. But yes. Para 3 clarifies the position.
Santosh, page 99. First case. So it is.
No.
Yes, 19.
However, to avoid any confusion, we again clarify that the 18 months.
One second. Let us go to the first paragraph. Why people went to the Supreme Court? Candidates went to the Supreme Court.
The grievance sought to be raised on behalf of the review petitioners and some of the applicants before this court is that though they were in employment and covered by the recognition order dated 22/9/2017, they believe that the judgment and order of this court dated 28/11/23 would come in their way if they want to make better their prospects by applying either in other institutions or for promotional avenues.
In the same institution, or they want to leave that institution and go to some other institution.
Yes.
Either way.
Yes.
This is answered. Yeah, they say para 2 is little confusing.
Yes.
But para 3 is just a confuser.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on
19/8/2019,
yes, 17 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying
slowly. For the purpose of
applying in other
institutions
or for promotional avenues.
News.
Yes.
What is meant by in other institutions?
Other institutions means
the institutions wherein they were employed,
yes,
not those institutions. If they want to jump from that institution to other institution,
including government or any other, yes, yes.
They will be treated as valid candidate.
But here is not the case, well. That's your lordship directed to read. I have read, but our case is different. Our stand is very different. I have your lordship may kindly see the death chart I've given. Just have a glance. Here, our case is they have no cause of action here. They are infiltrators because they were not eligible to apply for the post.
Why they were not?
Yes, that's our case.
How?
Your lordship may see the first 22/8/2023 date. My date chart. Today I have written it on. Statutory guidelines for recruitment of 20,000 numbers of junior teachers schematic that was passed on 22/8/2000 Annex 4 to the petition they have filed. Para 5(1)(I) prescribes qualification of category for class 1 to 5, which says
2-year diploma.
Yes. Class A, higher secondary, 2 years diploma in elementary education. This is the statutory rule that was introduced by the state government.
Elementary education means what?
Elementary education up to class 8, 1 to 8. This was introduced because after the amendment in the RT Act, your lordship must have seen in many cases that they allowed some teachers, in-service teachers in government to complete their OTT exam and so on so within 5 years. So this was the NCT as an academic authority, they have introduced this. As per the RT Act, NCT is the academic authority, none else. My learned friend, which you are showing that Minister of Human Resource and Development letter, that has no legal sanctity. But
Supreme Court said it has legal sanctity.
And I will also the Supreme Court, this judgment was passed by the honorable judges of the two division bench, two judgments. But there are 3 judges, constitutional bench, up to even 5 judges bench decisions are there. And that has not been taken into consideration when this judgment was passed.
Once. Then 2 questions will arise. According to you, the 2-judge bench judgment
yes,
is per incuriam.
Yes, per incuriam. I have taken this stand.
Can High Court consider the Supreme Court judgment is per incuriam?
Yeah, that I have taken a stand, but your lordship may kindly see. I will go. Let me place my case, then your lordship will pass it. Then on 10/9/23.
But you were a party to that. You are not a party to that judgment.
No. That judgment, Uttarakhand judgment, how it came to the appellate court by law. After the Bihar judgment, Patna High Court judgment, in Sanjay Yadav's case, Patna High Court held that 18 months is equivalent to that 2 years diploma. Accordingly, NCT wrote a letter to all the states and union territories to accept the verdict and accordingly take step. Then Uttarakhand also did the same thing. What happened? Uttarakhand government realized that their statutory rule does not prescribe 18 months diploma qualification. They have in 2012, my Lord Senior was saying, 2012 rule that also prescribes 2 years diploma course. So what they did, the earlier order on 15th January, which was issued allowing those students, that was withdrawn. And this was challenged before the Uttarakhand High Court. And Uttarakhand High Court then up to the Hon'Ble Apex Court. Your Lordship may kindly see the judgment my learned senior was showing. Your Lordship may kindly see paragraph 36 of the judgment.
Original judgment.
Yes, the judgment of Apex Court.
That's what, not review judgment. Paragraph 36.
Yes. All these things they have discussed. Yes.
No, your first contention, I'll just note down. You mean to say this judgment of the Apex Court is per inquirium?
Yeah, I've taken a stand. And I have also two judgments, constitutional bench judgment and one three-judge judgment I have placed. I've cited. You also I've given the citation.
Which considered?
Yes.
What?
Yes, what you Lordship may see Tej Prakash case.
The Apex Court judgment. Right. Dated.
Two judgments are there.
No, not that. This judgment date. 10/12/2024. No. 21/8/2024.
This Uttarakhand judgment?
No, Apex Court judgment.
28/11/23.
28/11/2023.
23 one.
Is a per inquirium judgment decision. Since it has not adverted to two larger bench decisions of the Apex Court. Which are those decisions?
One is Tej Prakash Pathak and others, 25/2025, two Supreme Court cases 1.
And another is?
Another is M.B. Nair and Union of India and others, 1993, two Supreme Court cases 429.
1993, two Supreme Court.
Two Supreme Court cases.
At that time, NCT Act had come into force.
1993.
So the NCT Act is considered in that judgment.
No,
the Act itself came thereafter.
In 93, yes. NCT Act came in 1993.
Whether that act is considered in that judgment?
29 December 93.
91.
That judgment I have seen, which you are now saying, that has nothing to do with the NCT Act.
No, that, yes. But your Lordship, find the principle decided by the division bench, larger bench. While answering the reference in Tej Prakash case, paragraph 65, I'm reading it. We therefore answer the reference in the following terms. This is a 5 judgment scale. 65.1. The recruitment process commences from the issuance of the advertisement calling for applications and ends with the filling of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. Even if such change is permissible under the extant rule or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. Then other points they have
how that judgment is relevant.
The state government in 2023, August 2023, introduced the statutory guidelines for recruitment of 20,000 teachers. There, the state government, the educational qualification eligibility condition was prescribed as a 2 years diploma course.
Correct.
Accordingly, on 10/9/23, the advertisement was issued. And thereafter, the petitioners, they knowing that they are not eligible, they applied for the post. E-admit card en masse was issued because there was, at that point of time there was no verification. So they attended the CBT test, and some of them, these petitioners, they got qualified and they also qualified and their names were listed in the provisional merit list. Then, in terms of the rule, statutory rule 8.4, on 16/1/2014, 16/2024, the document verification was made. There, it was found that they do not satisfy the eligibility criteria of 2 years diploma. And accordingly, as mentioned in the advertisement, and accordingly their candidature was rejected, then they have come to your lodge.
Once. Some of them were before the apex court. Yes or no?
Yes, some writ petitioners, they have filed here, and when the Uttarakhand case was, hearing was going on, they got it. Yes.
Some of the candidates under the very same advertisement were before the apex court. And transfer petitions were, because of that they were before the apex. The transfer petitions were disposed of, directing you to treat them as having complied with the requirement. Not true.
Yes, their petitions were allowed. I don't dispute that.
You don't dispute.
Yes.
If those persons are to be given recruitment,
yes,
why not these people? How can you classify? According to you, even they did not have 2-year diploma.
Yes.
But still the apex court said, give them the appointment orders. This is how the order reads.
Yes.
They are very rare orders. Generally consider for appointment, it's probably the terminology in service jurisprudence. But Supreme Court, after seeing its own judgment, dated 23/11, that you have seen that one, and the review judgment,
yes,
apex court said, give them appointment. Order is so specific. They did not have 2-year diploma.
They don't. But
just I want to know.
Yes.
So you want to say those who have brought orders from the apex court, to them we will admit to the recruitment process. Those who did not bring the orders, we exclude them because they don't comply with the advertisement.
No. That is not right. Our stand is that Honorable Supreme Court has, as a one-time dispensation, that the order passed. Yes, ma'am. Yes, your lordship.
No, under the very same advertisement. You admit, under the very same advertisement, identical candidates obtained the orders of the apex at the hands of
being transferred from this court. Yes, from being transferred from this honorable court. Yes.
You should have said there, your judgment is curium, therefore do not pass these orders.
Yes, that we have not said.
You have not done that. And now still you want to oppose the petition, saying that for one set of people they comply with the requirement because they have obtained the orders of the apex court. The other set of people, they are before this court, they have not obtained the orders of the apex court. Therefore, we deny the relief to them. How? Dichotomy. You were a party to that proceeding before the apex court, because those cases were withdrawn by the apex court to its portal from our court.
Yes. That is
therefore, you were a party and you suffered order there. And here you want to oppose.
You admitted that we have not raised this issue.
Then how? How many of such people were there before the apex court? 19 people. Yes. For 19 people, you are giving appointment orders, and to these people you don't want to give appointment orders.
No. Here now 25.
22, 23.
No, they are 200. I am just asking you. If you have suffered an order at the hands of the apex court, should you not extend the same benefit to rest of the people, whether they are here or not? Everybody should come to court. That is the reason why pendency happens.
No, they have by an amendment after by an amendment they brought to your lordship's notice. Initially in the read petition they have not pleaded. Yes, by an amendment they brought.
Question only there.
During the pendency of the writ application, the review petition was allowed.
Yes.
Subsequently, the TRP was
Yes.
allowed. That is why we are brought on record by way of amendment.
No, that's what I'm saying.
Yes.
You did not tell the apex court in all those matters. No, your judgment is per inquirium. Therefore, do not pass these orders. You agreed with the interpretation with the apex court list. And you suffered the order. Orders have attained finality. You have not filed review. On those orders, you have not filed review.
No review.
Nor have you filed review on the main judgment because you are not a party.
Yes.
Then on what ground you oppose the petitions? So you want to create two sets of people. One, those who obtain the orders of the court and therefore they are entitled to. Others, those who are similarly circumstanced, but they have not brought the apex court order, but they are here before this court, then to them we will not give. That only Muhammad bin Taghlaq can say. Not the welfare government. Rightly or wrongly, apex court say, review it, clarify. To remove the doubt, confusion. See that how the wording of the apex court judgment. However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons, those who were appointed prior to that cutoff during that 4-year period. We have completed 18 months diploma. If that is there, months diploma obtained by such persons who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional revenue. That will not arise here. And pursuant to this, other orders are made. 19 persons have secured the order. You want to, and you have to, unless you say, we will not abide by the Supreme Court order.
No,
that you may not say, perhaps.
Your lordship may pass.
Okay. Please give the dates, just if I need it.
Date chart are given. Date chart is.
Shorn of thickness of the pleadings, you find the documents accompanying the same, comma. The short question that calls for consideration of this code in these petitions having common fact matrix can be stated as a term. Whether the candidates who were in employment as on 10/8/2017, kindly be seated. I get confused with your standing up. And who have completed the diploma course of 18 months in the light of NCTE recognition order dated. Sit down and answer.
22/9/17.
22/9/2017 or to be treated as having 2 2-year diploma specified in the recruitment advertisement dated,
That is 10/9/23.
10/9/2023. Question mark. Next paragraph. Learned senior advocates appearing for the petitioners, drawing attention of the court to paragraphs 4.7, 4.10, 23, 25, 28, 29, 35, and 41 of the apex court judgment dated
28/11/23.
28/11/2023. 2023. Submit that the answer to the above question has to be in the affirmative. Affirmative. First, they adumbrate their submission by placing reliance on paragraphs 1 and 3 of the apex court review order of the said judgment. First, next paragraph. Learned AGA appearing for the OPs in his usual vehemence opposes the petition, contending that the answer to the above question has to be in the negative, in as much as the apex court judgment is perentorium, since it did not consider other larger bench judgments. Semicolon. It has been a settled position of service jurisprudence that what is prescribed in the advertisement as qualification has to be strictly complied with, more particularly when such a qualification is prescribed in terms of what has been prescribed by the NCTE, a statutory body under NCTE Act 1993. First, having heard the counsel appearing for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter for the following reasons. 1. Shorn of details, the apex court judgment dated 28/11/2023 makes it abundantly clear that the candidates who were in employment as on 10/8/2017 and have completed the diploma course of 18 months in terms of NCTE recognition order would be treated as having the requisite diploma of 2 years. First, this becomes abundantly clear by the observations of the apex court in paragraphs 1 and 3 of the review judgment, which read as under. Next paragraph. To the pointed question, learned AGA Mr. Lenka very fairly conceded that some of the candidates who were in the fray pursuant to the very same recruitment process were before this court And their transfer petitions filed in the apex court having been allowed, they were directed to be given appointment to the post in question on the ground that their 18-month diploma approximates to 2-year diploma prescribed in the advertisement. First off, it is very pertinent to notice the terminology of the apex court orders in respect of 19 such candidates, wherein the direction is not to consider for, not only not to consider for appointment, but to issue appointment orders. First one, it is not much in dispute that these petitioners are absolutely similarly circumstanced for those 19 persons who had knocked at the doors of apex court of the country and secured orders favorable to them. First, if contention of Mr. Lenka were to be countenanced and relief is to be denied to the petitioner's hearing, that would fall foul of Article 14 of the Constitution of India, in as much as this court would be creating a class within the class, there being absolutely no differential, nor the objects are to be achieved by arguable differential. First, in the above circumstances, these petitions succeed. A writ of certiorari issues quashing with that paragraph.
Reject list dated 5/8/24.
Paragraph.
Reject list is annexure 14 is mentioned. But that paragraph is selection. That is annexure 7, page 42. Relevant page is page 44. Clause number 5.
Quashing clause 5. Which disentitled candidates of the petitioner's kind who were having 18 months DEIED course.
DLED.
DEIED.
Diploma in Elementary Education.
Diploma in Elementary Education is quashed. Petitioners, such of the petitioners who were in employment as on
10/8/17.
10/8/2017, and we have done 18 months diploma course, into brackets, 6 months training having been subsumed within bracket complete, shall be treated as satisfying the requirement of 2-year diploma prescribed in the advertisement. Sir, a writ of mandamus issues to whom?
Posts are reserved. Already by virtue of the entry model, posts have been reserved.
Anyway,
Yes.
OP numbers?
OP number 1 and 2.
Who issues the appointment? There cannot be two. One has to issue.
And one.
OP number 1. You mentioned that. State government.
Yes.
State government. to issue appointment orders to the petitioners if they are otherwise eligible and qualified. First, just mention one more point. It is relevant to mention that this court, while the interim orders had reserved the vacancies so that if the petitioners succeed, they could be accommodated. First, therefore, there is no hardship or objection, sustainable objection as to why the petitioner should be denied the relief which the apex court itself has granted to rest of the candidates, namely the 19 persons who were before it. Now, within what period appointment orders would be issued? And if not issued, what should happen? Again, we don't want cases here. Mr. Lenka, within what period you will issue the appointment orders?
You also give 3 months.
3 months?
Yes.
Are you bringing appointment order papers from Switzerland?
No. That
Why 3 months? With effect from the date when you are giving appointment to rest of the people pursuant to apex court order.
Already they have been recruited.
They have been recruited.
The advertisement was for 20,000.
Within 6 months.
Yes.
Within 6 weeks.
6 weeks.
And it's a longer time.
Within 3 months.
3 months.
Within 3 months. And report compliance to the Registrar General of this court, failing which it is open to the petitioner to move an appropriate application for taking penal action against the officials for non-compliance. The penal action may include levy of very heavy costs and imprisonment also. If not
Your Lordship, may I wonder?
Yes.
Your Lordship's order was to confine to the petitioners.
No, I will not confine them.
Because
you want other people to come here.
May come.
Why? They should not. Apex court say, which is that judgment, similar relief should be granted to Krishnamurti. Which one? Seelalita. Others should not be driven to court at all. Court is not a happy thing. Apex court knows that.
But there must be a post must be there.
Well, we do not know. Whatever you want to do.
All cases.
Otherwise, see, we don't want any content petitions. I have made it very clear. Matters will come before this court, and I will implement the order.
Your Lordship's order.
Contempt.
Your Lordship's order will be complied within 3 months. That
challenge is
no, that year, because I am apprehending that after your Lordship's judgment.
No, 1 second. The judgments of the court are meant for implementation. They are not for photo framing. If implementation does not, you have argued, we have considered your contentions, very vociferously argued. We have considered, rightly or wrongly, we have handed an order. I have handed an order. As long as that order remains, it should be complied.
It will be complied.
Otherwise,
yes.
I have said what will happen. That also I have to warning, because this warning is given since this court has been observing day in and day out non-compliance of these orders, resulting into filing of plethora of contempt petitions and the like.
There are all the rest of all the cases listed are same.
Except the last one.
Last one
is only for reference. That is in respect to 19 persons. Your Lordship are directed for reference purpose. The last matter, T number.
That last one is already there. Where is that order of the apex court? Just give that order.
Yes.
Where the directed appointment. Separately, you give that.
Yes.
See, judgment of the apex court I need. Review judgment I need.
Yes.
Your advertisement copy I need. Then recognition order of the NCT I need. Okay. And orders of the apex court where appointment is to be given. Give separately. Okay, this will be the broad parameter of parameters of these will be parameters of my judgment. Little linguistic change, this side, that side.
We're grateful.
Before raising, I'll give to the court pastor.
Yes, get all those. Maybe that change. Yeah, next.
Item 82.
May it please your lordship. My lord, the petitioner is 72 years old, claiming promotion against the next junior without disturbing him, without having any grievance against him. On my own right, I am praying before your lordship. Both of us have retired. We have no rival claim in between.
After vacation. Now, because I have to frame this judgment, so many factors I have to consider. The short matters, if any.
My lord, may I just only one permission of
this matter in the February, first week of February.
May I only pray one thing?
Item 83.
It was hard exhaustively. May I pray? As to in January, it will be your lordship. 72 years January.
We will not become 74 by that time. Yes.
I appeal for the petition. Yeah. This matter is for final hearing. Lordship recollects. I very briefly summarize what the matter is on BC on the last date. Essentially a patent which has ceased, and today I'm seeking a direction from this court to allow me to restore it. Now, how these patents are validated, issued, they cease, and what is the procedure for restoration, that is all we are concerned with. We won't be going into the technical aspect. Lordship, there is a date chart.
Who is your opponent? You are here. Start.
Lordship, there's a short.
Is it a short matter or
very short?
Long? Short
very
matter?
short. Very short. If Lordship gives me 20 minutes by the clock, I can conclude the entire argument, including the facts. Within 15 minutes, I'll conclude.
Intellectual property.
Actually, the matter is on the procedural side. I will just quickly, Lordship may ask me to hurry it up, I will hurry it up.
No, you can hurry, but I cannot hurry judgment.
I will make it very concise and clear.
Consequences.
Now, Lordship.
Brother, we'll have this matter, your matter, we'll have it in second week of January. Second week of January. Yes.
Lordship, there's a date chart on record if Lordship has that. I've summarized the entire case within those 5-6 pages. I'm tendering a copy also.
Any urgency? What is the urgency?
Lordship, the urgency is that my patent has ceased. Now, when I describe the patent, Lordship will understand the urgency. Because if it is not restored, there are so many players in the market who want to use this technology. So I'll just quickly.
Your date chart itself runs into 7 pages.
No, that is inclusive of all the annexure page numbers I've mentioned.
Or some other date.
Lordship, I've traveled all the way. If Lordship hears me for 10 minutes, if that I'm not able to
the short matters.
It's a very short.
Requires consideration.
Not at all, Lordship. I'll in fact point out why it. Lordship, may I request this?
Next.
Lordship's permission, may I request?
No.
Lordship, this is only with respect to.
Second week. Yes.
Lordship, in that
any date you choose. If you want data, you will give.
Lordship,
you can argue or online also.
Any date as soon as possible.
Any date you choose, whichever date you want.
January, second week.
Second week of January. Next. Any short matters?
Item 85.
Item number 85, it will take some time. But
85.
Since your lordship is only asking for short matters, my lord.
It is not.
So your lordship, it is not.
Not that
short. No, you himself said it is not that short.
It is not.
Because your lordship have only entered those matters which are short. So your lordship fix an early date because
the first week of February.
No, my lord, prior.
Because many matters I have already.
Can I pray for second week or third week?
One comment.
But interim order to what?
Interim order. You have interim order?
That is subject to result.
I think 86.
Item 86.
86 was similar matter, covered matter, my lord. After the Jitalwa's case, simply kindly, I corrected this case. For appointment of a rehabilitation assistance scheme.
Have you given copies?
Yes, I have already given and I have also.
Because in the subsequent order, I have later very changed it.
In this rejection order is quashed and earlier, basing upon the earlier judgment. Now the Jitalwa case is come, my lord.
So lordship dispose of for passing the direct to the opposition work, consider the case.
Yes, sir, consideration.
My lord. Same order.
It is same.
Public.
Serial number?
Serial number 86, my lord. I am wrongly dictated 100.
Yes, but 86 it is code of yes.
87, my lord, 87. It's a covered matter, my lord. Just disengagement order on the basis of involvement in a criminal proceeding. My lord, covered matter I had given the.
How it is covered. Hearing now. Hearing
It, my lord, what has happened is disengagement order has been passed only because mere pendency of a registration of FIR and detention in judicial custody. Disagreement.
NDPS
Requires citation. Latest judgment has come now, Apex Court judgment.
Yes.
Which has reviewed entire law, surveyed entire law.
That has been taken care of by the coordinate bench.
Judgment.
No, not last week.
Just look into that, come back.
Item 88.
Last week of January. Yes.
Last week, lordship directed to take instruction similar as the other person they are getting, my lord. The house rent benefit, my lord, 4% to 8%, my lord.
You had argued that, na?
And they argued, lordship, last occasion, lordship, 18.
You take time against you in that. That 8% or 4%?
No, 4% or 8%? 8%. The lordship last occasion directed the state government to take instruction on similar situation.
Whether, Mr. G, you said that you would bring whether similar persons were granted benefit or not, house rent benefit.
Yes, my lord. But
you had taken time for that purpose.
Yes. Short date may be given for that.
Second week of January. Yes.
Item 89.
My lord, 89 cover matter, my lord. Matter is related to transfer of a teacher on the basis of the recommendation of the Hon'Ble MP and ML minor.
Subject to 7.4.
7.4.
4.7. 4.7.
The subject matter of subject to 4.0.
Sub item same also.
Sub item also same.
Same one.
Okay.
Item 90. Item 90.
Your lordship, my lord, the petitioner was dismissed from service on the ground of forgery of the city certificate. My lord, the board wrongly stated that it was, we apologize, you sent a wrong information. Actually, the certificate is genuine. Thereafter, your lordship fixed today. It's because they have not reinstated me since last 1 year, 8 months. I am now out of employment, my lord.
So immediately in January, we will have third week of January.
Today, I am not filing. No, I am not. Your lordship, to file the reply.
What reply they will say? Because they only said it's a genuine certificate.
That is why your lordship taking seriousness.
Cover matter, your lordship, 150 weekly list. Cover matter, wrongful termination, deprivation for the area salary. Your lordship already passed.
Just show it to. Is it covered? Mr. G.
That up to 125 it is being listed. Up to.
I have already corrected that. Same order has to be passed. Annexation 16 series, that order, consequential order.
The interest and so many other things are we have ordered, let them look into. If you give up the interest and other things, then we may direct them.
Same order has to be also.
Then they have to look into that. Otherwise, the financial consequences are there. Back wages, so many things I have ordered. But therefore, that needs, I will not, if they agree, well and good, just look into that.
My lord, I had seen that. My file has not come. Our allotment.
Tomorrow supplementary, your lordship may put it.
That's yes. We have our allotments up to 125, not beyond that.
All right, put it day after tomorrow.
May I? This matter, cover matter of Lokanath Berakas in leader promotion matter.
Number item.
210.
That matter.
210.
No, it is not there. It is not within our
serious. Unless they have to look into, na?
Sir,
Their file they have to look into, not your order. Their file they have to
for
look
the
into.
vehicle,
and then say whether it's
for
covered or
the
not.
vehicle, 125 matters are being in the list.
Rest of the things are not there yet.
That is not there, man. That is the.
Quite.
What I pray tomorrow, maybe
So much urgency, I do not know. What heavens are falling down?
Similarly situated
I am
persons.
retiring only in July. You want me to retire earlier?
Well, they have got the similarly situated persons, they have got the order. But here, I pray.
Day after tomorrow.
Yes, yes, ma'am.
Item 154
210
of a weekly list.
Ah.
I pray he should give the counter. For he did not file the counter, inspector will court's order. And I pray let it come 3rd week of January so that in the meanwhile, and in the meanwhile they will file the counter.
It is open to the other thing to file counter evening. Before that.
Item 38 of the weekly, that's a covered matter. 23 persons are already getting the benefit, Your Lordship.
23, see that within 125, na? Just 38.
Yes. Weekly list 38.
That's why I have given the copy already.
What is the nature of order? If it is consequential, then they have to look into that. Just see, Mr. G, what is the nature of order? If it is considered, etc.
This is a Mr. Link. Order.
We have already filed counter. Your Lordship may call them.
You have filed counter?
Yes, yes.
First week, second week of January.